Sale of Goods Act only relating to auction. We will take up law of tort and law of arbitration and conciliation. Before I start, let me introduce myself very briefly. As you must have known that I am R.K. Khurana. I am Rajesh Kumar Khurana. I am fellow member of the Institute of Cost Accountants of India, also fellow member of the Institute of Company Secretaries of India. I have done my executive masters in international business and LLB. I have worked at various places, a long experience of that starting from 1983 till 2013. So initially I was CFO of Delhi Tourism Development Corporation, a state government undertaking between the year 1983 to 1987. And from 1987 to 1991, at the same place, I was CFO company secretary of the same undertaking, that is state government undertaking. I left that in 91 to join India International Center as controller of accounts. I stayed there for 4 years and left that in 94 to join FICCI, Federation of Indian Chamber of Commerce and Industry, again as financial controller. I left that in early 96 to join International Labour Organization. International Labour Organization, or ILO, is a specialized agency of the UN where I continued to work till June 2013. I retired from there in June 2013 to start my own legal practice. With this brief introduction, we can also set up a bit of a rule of the game today. And you are already aware that at least can you see my video? Anybody who can see my video? Sandeep?
Yes,
Yes, sir. Yes, sir.
we can
Yeah,
see the PPT, all right.
you can
Yes,
see
sir.
my PPT also. That's very
Yeah,
good.
yeah, yeah, yeah.
While I cannot directly see you continuously, but once in a while, if I close my PPT, then I can see many of you or most of you. So what I do is when I start my presentation, you might have certain doubts, questions, certain things not clear, certain things maybe not properly heard or whatever it may be. You can take liberty of unmuting yourself and ask the question over and there and then, or alternatively you can write down that question or a query. So as soon as we pass or go through about half of the presentation, we will give ourselves a little time to chat on or to resolve some of the queries that you may have on that particular subject. Is it okay? So
Yeah,
another thing before I start, I have already spelled out to you that we propose to take up with you 4 topics in a matter of 3 hours between now and till around 1:15. So this is both a challenge as well as an opportunity. Challenge is that it is a large syllabus. How do we cover in a matter of just 3 hours? Any of these topics may by itself take 3 hours. But the opportunity is that we are all educated people and we have all studied these topics at good length. The only objective is that we want to recapitulate ourselves on the theory or the legal part of this particular subject. And wherever you feel like the topic is rather easy and I'm spending too much of time on a particular issue, feel free to call me. I can even fast forward certain slides or certain part of the lecture and be according to your choice. So I'm like a remote TV where remote control is in your hand. You can control both the subject that you want me to speak on, that is the channel, and also the pace with which you want me to speak and the topic which you want me to speak. I'm also fortunate to be bilingual. I can speak both in English as well as in Hindi. So whichever language you feel like, I can change over at any point of time. With this brief stating together of the rule of game. So is it okay that I start with Indian Contract Act, or you want me to start with law of tort or arbitration or any other law, which I have told you that we have 4 topics? Anything you feel like I can start with. But I have uploaded my PPT on Indian Contract Act, yeah, but I have no option. I'm quite flexible to change this. Can
Sir,
you
is
tell
it related to value organization?
Pardon, sir?
The Indian Contract Act.
Yeah.
do we encounter such usefulness of Contract Act
Definitely,
as a valuer? If such is
this
the case, you go ahead, sir. Thank you.
okay. This is the enactment which is maximum used in our day-to-day life. Every day we must be entering into tens of contracts of boarding a bus or a public transport to go to our workplace, buying vegetables or fruits, placing order on e-commerce companies to buy something, coming to the office and issuing tenders, and then processing of those tenders. So all these activities that do which involves any kind of a buying or selling or even entering into any kind of a contract for providing of a service has a usage of the Indian Contract Act. You know that. So, and any contract relating to supply of services, you are accepting a particular employment or you are accepting or giving a engagement contract for consultancy. So anything and everything involved functioning of or some knowledge about the Indian contract. So that is the importance of the Indian Contract Act. So this is the syllabus I have with you. You can even take a sort of a photocopy and take a photo and see that by the end of these 3 hours, we have run through and we have covered the entire syllabus.
You would be supplying us the copy of it?
Yes, I will be supplying the copy of the PPT to you.
Thank you.
No
Sir,
problem.
one more submission, sir.
Yes.
Uh, throw some one or two examples while detailing each topic so that
So where
we
I,
are
I
have
will
to,
I will
one,
try my level best. I will try my level best. But wherever you feel that some example is wanting, feel free to intervene me over there, wherever you want me to.
X mode.
So I hope that with this kind of a technology available, we'll try to make this presentation as much interactive as possible. Okay, so that it doesn't end up only resulting into any boring kind of a presentation. So that's how we propose to take up, and with your intervention I hope that it can become even much more interesting.
one
So
more.
as far as the Indian Contract Act is concerned, I have divided this into these kind of a topics. We will take up introduction of contracts, essential elements of contract, formation of contracts, and then certain essential elements of contract such as offer and acceptance, the lawful consideration, lawful objective, competency of the party. These we will take up, and then little more on the offer and acceptance, and then contingent types of contracts. We have a contingent contract, voidable contracts, void contracts, void agreements, then novation, recession, alteration. These are some of the terms which are used in the Indian Contract Act. Then we will take up the performance of the contract. Having entered into contract, how do we perform these? And in case one of the party is unable to perform his or her or its part of the contract, then what are the consequences for the breach of the contract? And we have two special contract, that is contract of indemnity and contract of guarantee is one, and then we have agency agreements. So friends, this law relating to contract in India is contained in Indian Contract Act 1872, pretty old one, and it came into force with effect from 1st September 1872, and it is applicable to all over the countries. The Act determines the circumstances in which the promises made by the parties to a contract shall be legally binding on them. So here I would like to spend a minute. See, this contract is so liberal that it calls upon, it gives freedom to all of us to decide our own terms of contract. So whenever you want to enter into contract to say procure, say you want to buy a car and you want to enter into contract, you have to decide which car you want to buy and then approach the prospective seller and then decide upon the price, mutually agree upon the price, terms and conditions of the delivery, and your roles and responsibility. And then if you want, you can even enter into a written kind of an agreement. If you don't want, you can stay together and have it only oral contract. You can also have a contract by not even spoken from the mouth, by just implied from your conduct. So this is the liberty. But anything, when something goes wrong, that is the Indian Contract Act provides for certain broad framework that how those resolutions will be brought about. The Indian Contract Act deals with the enforcement of these rights and duties once they are entered into between the parties. So the law shall enforce only what the parties have agreed to be bound. I have already told you that no court tells us the which contract we should enter into and which contract we should not enter into. But once we have entered into a contract, the law shall enforce only that which we have agreed to abide by. So rights and obligations created by the party shall be performed, and their non-performance shall give rise to legal consequences. That means in case we enter into a contract and one of the party is unable to, unwilling to, or fails to perform its parts of the duty, that party is said to have gone into breach of that contract. And any party, any person who is aggrieved by the breach by one party, he or she can go to the court of law and seek a remedy. Before I take up the section by section or details of the Indian Contract Act, let me give you a broad framework. The Act, when it was brought into force in 1872, it was a pretty large one. It included within its framework the what is called today called the Sale of Goods Act. These provisions relating to the sale of goods were also incorporated from section 76 to 123. But later on, it was thought in the year 1930 that the Sale of Goods Act is a independent by itself. It has certain specific provisions, particularly relating to warranty, guarantee, rights of the unpaid seller, principles of caveat emptor. They could not be accommodated within the Indian Contract Act. So these sections were repealed from the Indian Contract Act and enacted as a separate law. Like that, in the year 1932, the question came where the partnership till 1932, Partnership Act was also part of the Indian Contract Act itself. Then it was in the 1932 that sections 239 to 266 were repealed and enacted into separate law, which today is called the Partnership Act 1932. Presently, after repealing of these two major chapters out of the Indian Contract Act, we have two parts, that is general principles of law of contract, which is covered from section 1 to section 75, and then it includes certain special kinds of contracts such as indemnity guarantee, bailment and pledge, and law of agency, which are given from section 124 to 238. So friends, in case you happen to download this particular enactment, you will find that to start with, it covers the from section 1 to 75 in a serial order. And suddenly you will find that section 76 to 123 are not there in the Indian Contract Act. And later on, it straightaway starts from section 124 to 238. Of course, once you read up to 238, you will not have the need to look further. So this is a little bit of history I wanted to tell you. So whenever we want to study Contract Act, so first question which comes to our mind is as to what is a contract. And section 2H of the Act defines the term contract as an agreement enforceable by law is a contract. So again, our problem remains then what is an agreement? And particularly in our daily life, sometimes or most often we use the words interchangeably. I have entered into an agreement for supply of, or I have entered into agreement for availing the services of, I have entered into a consultancy assignment and signed an agreement to that effect. And sometimes we use the word that parties have entered into a contract. So it is necessary to understand as to what is the difference between the agreement and a contract. So it says an agreement enforceable by law is a contract. This definition resolves that a contract is fundamentally an agreement, yes, that binds the parties legally. Thus, a contract is equal to agreement plus enforceability. Then what is an agreement? An agreement consists of an offer by one party and its acceptance by the party to whom the offer is made. So early in the morning, you stand up and go to, say, provision store and tell that you want to buy bread, you want to buy rice, you want to buy soap and detergents and whatever not. You offer that you want to buy this, and shopkeeper tells you the price which you accept. So there is an offer, there is an acceptance. So long as there is an offer and acceptance, agreement comes into force. Now, what is an offer? That means whenever we propose to another person that you want to signify to another person your willingness to do with a view to obtain the assent of that party, then the person who makes an offer or the person who signifies his willingness is called offerer, or he is said to have made an offer. Friends, this making of an offer may be of two kinds. One is willingness to do or to abstain from doing. What is the abstain from doing? Say you and I have been into partnership, and today we want to first we want to enter into the partnership. One of the things we may want to abstain is we may want both the partners to abstain from doing any other professional work in competition with the partnership. So both of us say you will devote your full time to this partnership and will abstain from doing any other work during the period of this partnership. So that is the abstaining part. And in case any of the partner performs or engages himself into doing any other work in addition to his being a member of the partnership, so he would be deemed to have violated the provision of the partnership, or he should be deemed to be in breach of the contract of partnership. There could be another example. Say you and I have been into partnership for say 2-3 years, and now we want to dissolve the partnership. One of the partnership want to take the goodwill and he want to carry on with the partnership, and the other person gets his compensation. The person who gets his compensation, so he will be richer by that much amount. But the person who wants to carry on with the partnership, who has bought a goodwill, would want that the person getting the goodwill should abstain from starting any or carrying on as same work as he has been doing as a partnership. So he agrees to abstain from doing the similar business in that area, say for a period of 3 or 5 years. So he gets a consideration and he gives in return a promise that he will not undertake any business relating to the partnership for such and such number of years. So that is the abstinence part. What is an acceptance? When a person to whom the offer is made signifies his assent, that means when he agrees, he say yes to the proposal, so the proposal is said to have been accepted. So agreement comes in. So as soon as there is an offer by one party to do or to abstain from doing anything, another party accepts it. So there is an offer, there is an acceptance, agreement comes into existence. So section 2B of the Indian Contract Act defines a proposal or an offer when accepted becomes a promise. So promise is the same thing as an agreement. So friend, there are certain rules as to offer and acceptance. Let me take those rules first with you before I take you further. Offer. So one thing you must have known by now that there has to be minimum of 2 parties. I cannot enter into agreement with myself. However big I may be ONGC, I may be State Bank of India, or I may be Siemens, such as big a company as those, but I cannot enter into agreement with myself. There has to be minimum of 2 parties in order to enter into an agreement. And if one person makes an offer, the offer must be clear, definite, complete, and it must not be vague. That means since you make an offer, another party has to accept it. In case the offer is not clear, definite, and complete, and if it is vague, then it will be difficult to enforce that agreement, because one party will think something, other party will think something different. So it will be difficult to implement the contract. So offer will be said to be not to be specific. Like that, offer must be communicated to the offeree. If you make an offer to deliver something to me, but do not convey it to me, how do I accept it? How do I know that you are making an offer? So it must be communicated to the offeree. The communication of offer must be made by express words, that is oral or written, or it may be implied from the conduct of the parties. So there could be an express offer, which could be by way of a written communication, or it could be oral communication also is as good. In fact, as you see the real life, most of the agreement on our day-to-day life which we enter into, they are not in writing, they are only oral agreement. But there are some important agreements having long-term implications, so that we put down to write, say, agreement for purchase of a house, agreement to enter into partnership, agreement to sale or purchase over a long period of time. Those are the kind of a very complicated terms and conditions are involved. You put down to writing. Then sometimes the offer may also be implied offer. That means neither spoken from the word of mouth nor communicated in writing, but it is implied from the conduct of the party. Say you see the public transport, a bus going on a route number, say 32. People know that 32 takes us from place A to B via D, E, F. That route is taken. So anybody who boards the bus is implied to have accepted the offer of the bus to be carried from one place to another. Then where an offer is made to a particular, there could be a specific offer, there could be a general offer. Sometimes the offer is made to the people at large. Anybody who wants, he can accept it. Say you have lost something precious and you want that item to be traced. Say you have lost a key of your car and you make an offer. Anybody who finds the key of my car, I will reward him by a price of say 1,000 rupees. So it's a general offer. Anybody who brings the key to you, you are obliged to pay him 1,000 rupees. But there could also be a specific offer where the offer is made to a particular or a specific person. So whenever the offer is made general, it can be accepted by anybody. But whenever an offer is made to a specific person, it can be accepted only by that particular person. Just I give an example that Mr. A has communicated to you the proposal for selling of his car for say 2 lakh rupees, and proposal reaches you, but before you have decided, your friend has got across that email and he communicates the acceptance. Yes, I am willing to buy your car for 2 lakh rupees. Is your friend who has to whom the offer was not made entitled to accept such offer? No, he cannot, is not entitled to accept such offer because the offer has been made to a specific person. It is not a general offer. But if your friend has made a general offer, anybody who wanting to buy my car, I'm in a hurry to sell it, I'm willing to sell it for 2 lakh of rupees. In that case, it's a general offer. It can be accepted by anybody. So anybody who accepts it and agrees to pay 2 lakh rupees, he will be said to have purchased that car. Okay, like that, there are certain rules as to acceptance of the proposal. Acceptance of the contract emerges from acceptance. The contract emerges from acceptance of an offer. Acceptance is an act of assenting to by the offeree to an offer. So, as per section 2B of the Contract Act, when a person to whom the proposal is made signifies his assent thereto, proposal is said to have been accepted. So to recapitulate, friends, in order to enter into an agreement, there is a proposal, which is proposal when accepted becomes an promise, and promise is the same thing as called an agreement. A promise or set of promises forming consideration for each other is called an agreement. An agreement plus what is required, I will take up with you in a little later. So agreement plus something more is called contract. So what are the essential elements of the contract? So in that sense, I have said that a contract is a subset of an agreement. So every agreement, every contract is essentially an agreement, but every agreement need not necessarily be contract. So in order to be a contract, there should be enforceability. Normally there are two kinds of agreement. There are certain social kind of a understanding we enter into with our family. We promise our spouse something, and we know that even if we violate or there is a breach of that agreement, some voice has started coming. Is somebody is keeping your yeah, thank you very much. Somebody has mute. Now you have muted yourself, so this voice has stopped. Otherwise, there was a disturbance. So, friends, in case there is an agreement and such an agreement is enforceable in the court of law, then it becomes a contract. Then why is it that certain agreements are not enforceable in the court of law? There are certain kind of a social understanding. You promise your friend that you will go for a coffee at such and such place, or go for a film or a circus show, and on a spur of the moment, either your friend doesn't reach you, or you do not reach. So in case there is a such kind of a violation, will your friend take you to the sue you in a court of law? No, he will not sue you in a court of law. You know that it was just like a social kind of an understanding. But in case you give time to your advocate, or your advocate tells you to come at a particular time at the particular place, I will give you advice at that point of time. And in case you go and advocate doesn't turn up, and in case advocate comes and you do not turn up, then there is an understanding that any aggrieved party, anybody who who is adversely affected by other party not fulfilling his part of the obligation, they can take him to the court of law. So there has to be there has to be enforceability. When does the enforceability come? Section 10 of the Indian Contract Act says, according to section 10, all agreements are contract if they are made by free consent of the parties competent to contract for lawful consideration and with lawful objective, and are not hereby expressed to be void. That means in order to be a contract, there should be offer and acceptance. Then in addition to that, so there is a proposal, there has to be agreement. And once there is an agreement, then there should be 5 additional elements. And these are that contract agreements must have been arrived at with the free consent of the parties. When is the consent free? When is not the consent free? I will take up in the next couple of slides. Parties should be competent to contract. When is party competent to contract? When the parties are not competent to contract, that also we have to take up. Then whenever the persons enter into an agreement contract with each other, there must be a consideration. There must be mutual give and take. If you promise to give me something and in return I promise not to give you anything at all, that means there is no consideration at all. So there has to be consideration. Like that, there has to be object, and the kind of agreements we want to enter into, they should not be expressly declared under the Indian Contract Act to be void. So these are the 5 essential. Since we are now proceeding, friends, we started with the agreement. Then in detail, we studied offer. We studied also acceptance. And once there is an offer by one person and acceptance by another person, there is a proposal, promise, and the promise is promise or set of promises becomes an agreement, and agreement plus these 5 elements becomes a contract. Now let me take up with you little more about these 5 elements. Before I take these 5 elements, can I halt for a minute and just ask you whether you are able to follow whatever I am saying, or it is all sounding to be very confusing?
So the thing is that I am just seeing the whole thing, but the legal matters, it sounds to be an odd.
But okay, now so far I have told you only three things: offer,
Yes, sir.
acceptance, agreement, contract. Now you are
And
able to
promise,
make.
sir. Yeah,
And
that I can make down. Offer, contract, and promise.
yes, offer, acceptance,
And promise.
agreement, and contract.
Huh.
So that's what I have said so far, except that I have said in a slightly detailed manner. But
So,
have you?
sir, yeah, sir, my question is, sir,
Yes.
these are the definitions, right?
Yes.
So now, how will we apply it in our real life? That is the thing.
In real life, even a rickshaw puller who had never been to school, who cannot put his signature at
Hmm,
all, he
hmm.
also enters into an agreement. You
Yeah,
take him
definitely.
for a metro station, ask him
Yeah,
to take you to some place 2 kilometers away.
yeah,
He puts the price, you accept it, and you carry
uh,
him to the place. And at
yeah,
that place, if you say that I don't want to give you 20 rupees, the rickshaw
uh,
wala say, no, I agreed for 20 rupees. So he's assertive, so he follows.
yeah,
At
yeah,
least in your case, you are an engineer or a professional, you know it much better. So even most illiterate persons,
hmm,
uh, in a unconsciously, they are aware of these terms. They also implement on a day-to-day basis. But since you and I, as a professional, have to enter into certain kinds of a contract having much greater stake, so we are supposed to know little more of this theory.
yeah.
And this
That's
is the
right.
theory which I am going to study with you. I hope. Okay, let me also ask you one thing.
Yeah.
Before this class today, have you never attended a lecture on this particular subject?
Yes, we have
Uh,
attended.
Yes, sir.
sir, I
You,
haven't. I haven't.
you have not attended. So then I feel even more delighted that by spending around 20 minutes with you, you are able to make out certain basic elements relating to entering into a contract, which we do so on a day-to-day basis. Is it okay?
Yes, sir.
Yes.
But the thing is
Okay.
that when we see legal papers,
Yes, yes,
so legal deeds, or legal papers, I
yes,
what I have seen these terminologies and
yes,
their
yes, yes,
definitions.
yes, yes,
So
yes, and
so when we will be dealing in real life, so
yes,
this kind of terminologies has to be implemented so
ex-
that we will be in a safe condition, right, sir?
exactly, exactly. So,
Okay, sir.
say for example, you say you promise your wife that you will get her a X amount of jewelry on a particular day,
Yeah.
and if she sues you in a court of law that why are you not getting me the jewelry, then you should be able to tell her that it was just a social understanding and it was not a legally enforceable contract.
Okay.
Or you could also be able to tell her that, madam, no consideration has flowed from you to me, so this contract is not enforceable.
Yeah, yeah, yeah.
Like that,
Okay.
there could be certain. I will take you to a little more intricate thing, but if you are able to understand basics, so my purpose of being here is I feel very happy that I am able to convey to you certain basic issues relating to a contract, right? Okay, a contract is a con, what is a contract? Is an agreement is a basis of agreement is a basis of every contract. That means agreement may contain certain agreements which are enforceable. They become the contract, but there may remain certain agreement. They may remain agreement, but they will not become contract. So contract is a more refined kind of an agreement, little more legally, because otherwise, what is the objective of having a contract? Because the objective of having a contract is that in case any of the party vitiates, do not fulfill his part of the obligation, that you should be able to take a legal remedy in the by way of an enforcement in the court of law. But if you have entered into an agreement which is not a contract, which does not have any of those five essential elements, such as free consent, lawful consideration, lawful object, then they are not declared to be void. So then you will not be able to enforce this. Is it okay?
Hello,
Okay.
sir.
Yes, sir. Yes, sir.
I
Yes,
have a
Ganesh.
query.
Say, I told you a little while before, certain agreements are not contract. Which agreements are not contracts? That means agreement between the family members are only agreements as they may be, maybe there may be no legal intention to enforce them. So as you make lots of promises to your children, to your spouse, to your parents, and many of those promises are not fulfilled. Even if they are not fulfilled, you are not worried. You know that the other party will not take you to the court of law. Similarly, agreements by incompetent persons, if you enter into an agreement with a minor are with a person of an unsound mind, they cannot be converted into contracts. So is it clear?
I have one question, sir.
Yes, please.
Yeah, actually, if there is no consideration from either
Yes.
party, since there is an agreement entered, I have seen practically and I have encountered similar problem on of the EPC contract.
Yes.
That particular contractor, because there is an LOI awarded. After
Yes.
that, there is an agreement made, but there
Yeah.
was no RA bill. Means there is no running bill or no performance guarantee or bond submitted. Prior to that, that contractor gave the company a notice
Yes.
because this is not enforceable contract because there is no consideration made. So this contractor is just 2-line letter has come, not enforceable. We are not abiding by the contract law. Is it a correct approach? Means there must be a consideration because there is a gap between in a real practical life there is a LOI, and the basis of LOI the contractor supposed to accept the LOI, and then is a agreement, and on the basis of agreement after that there is a bond, and then the consideration money will flow. But before money flow, there is always a risk, sir. Is it always a risk because the contractor is not having any money from the company?
Yes.
So is there always risk he can escape without citing the clause that there is no consideration to me from you, so I am not abide by the contractual provision. Is it correct?
As far as I can see, when the agreement was entered into, it is not correct to say that there was no consideration. The contractor must have agreed to perform certain thing, and in return of which the company must have promised to pay him some lowest price, which you have arrived at through the competitive bidding. So initial part, I think maybe contractor was not right, but subsequently the contractor might have performed a part of the work. That's what my guess is there, what I hear from you or what my other friends hear from you, that maybe the company has not paid on time, and then at that time contractor wants to back out. He said, oh gentlemen, you have not paid me so far anything, nothing has flowed from your side, I am only doing my part of the work, so therefore I also agree, I also decide to rescind the contract, break the contract, I will not enter into contract with you. It could be something like that, but if it is something different than that, you can even speak to me separately instead of taking everybody's time. Is it okay? Is it like this, or it was something different?
No, not everybody's time. It is because you told there is a consideration. That's why I asked that consideration. Without that, it is not enforceable.
So in the beginning, there was a consider because the company issued a tender, said that company wants to have procurement of these things or construction of these works. Anybody who is willing to do so should quote their lowest prices. So somebody said that, okay, you pay me this lowest price and I will do the execution for you. So there was a consideration, at least in the beginning, there was a consideration.
So questions are being allowed to ask, correct?
Yes, please, you are allowed to ask. Otherwise, what is the purpose? You are such senior people, you are allowed to ask. Okay.
You told me that I am wasting other time.
No. I did not mean that. But in case something involved a longer discussion, say, in the beginning I said, I'm sorry that if you have misunderstood it that way. So if it involves some longish discussion, then we can do it separately. Otherwise, so long as it is in the interest of all of us, so I will be very liberal to answer anything. Okay.
Thank you,
so wherever I find that
I have one question.
Wherever you find that I am unable to answer it, so I will express so that there is no harm in admitting the shortcoming. Okay.
Okay.
Sir, I have a
Okay.
query.
So I said agreement from the. I was trying to.
Sir, I have one basic question.
Yes, please do.
Sir,
Yeah, I have a query, sir.
Yes.
Either retail or verbal. I take some professional assignment on verbal basis and later on party denied from the commitment. What type of legal action I can take? The second question is that, sir, you said that agreement should be there. Agreement should be made on plain paper. Is it valid on legal ground, or it should be done on bond paper?
That's a very interesting thing. That depends upon the what kind of agreement you enter into. If you are entering into an agreement which involves supply of any movable commodities, movable property, in that case there is no need for a stamp paper. So it could be even an oral agreement, so you can also put down on a paper. But then there is also an application of various laws. For example, as far as agreement is concerned, entering into agreement is concerned, since there is no need even for a written contract, so there is no question of the stamp paper or anything. But now let me tell you certain applications of different enactments. Say there is a Transfer of Property Act, which provides that any agreement for sale or transfer or purchase or lease or license of a immovable property having a value exceeding 100 rupees, it has to be in writing and it has to be registered. So if your agreement relates to transfer of an immovable property having this 100 rupees is since 1882, ever since the Transfer of Property Act came into being. So that agreement has to be writing, it has to also to be registered. Before you ask further question, let me also carry it further. There is also an application of the Indian Stamp Act, which requires that whenever you want to register an agreement in a particular state, you have to pay a stamp duty. So to that extent, there is a question of a stamp duty also come into being. So there is a simple Indian Contract Act, there is a Transfer of Property Act, there is a law of registration, there is a law of Stamp Act. So when you apply all these enactments, so lots of complications get into the real life. Have I answered this properly?
Sir,
Yeah, thank you, sir.
one submission, sir.
Yeah.
You said it is to be registered.
No, if it is a agreement relating to transfer of an immovable property, the registration is compulsory.
Registration means sub-registrar we need to go.
Exactly. You have to go to the office of the sub-registrar, get your agreement registered. Yes. Like that, I tell you another example. I told you that any agreement relating to transfer of movable property does not require a registration. Okay, now I'm selling a car. Does it require registration? As far as transfer of property is concerned, as far as Indian Contract Act is concerned, it does not require any registration. But then there is a question of a Motor Vehicle Act. Motor Vehicle Act requires that anybody who owns a motor vehicle has to get itself registered in his name. So there is a need for a registration, and once you want to change it, you want to sell your old car to somebody, so somebody else's name has to be written in place of your name in the books of the motor vehicle authorities, that means Directorate of Transport. So then has to that ownership has to be transferred in the books of the or in the register of the Directorate of Transport. So then written document has to be there. Like that, when there is a complication of various laws, implementation of various laws, so requirements of all those laws have to be met. Is it clear? Is it not interesting?
Yes, sir. Yes, sir. So can you give any
you
details?
all that?
Yes, sir. Can you give any details of stamp paper to be made agreements? Suppose a valuer,
Yes.
being a valuer,
Yes.
I may
For
get
example,
an offer. And what amount
Yes.
of bond paper we need to make an agreement with the party?
Yes. So there is an Indian Stamp Act which also has a schedule attached with it. While the Indian Stamp Act is around 20 pages, the schedule attached with the particular enactment is runs into 15 pages, which says, say, if you want to give an indemnity bond, you have to use a stamp paper of 100 rupees. If you want to stand a guarantee for somebody, then it has to be stamp duty of this price. If you want to enter into sale or purchase of a immovable property, the stamp duty has to be 6% or 8%, depending upon whether state to state, and also depending upon the gender in whose name property is getting registered. So for that, you have to study a separate act altogether. I'm glad that you are feeling so curious to know all these things, but it's interesting for me also to share these things. Is it okay? Anything more you want to ask?
Yes, sir.
Yes, sir. Stamp paper amount.
No, sir,
How
please
much
go
to be amount to be entered?
I said it varies from depending upon the nature of the transaction. If
No,
the
as a
simple
valuer. No,
it's
not like that, sir. As a valuer, some X person is hiring me. So what is that amount of bond paper to be made an agreement or offer letter to be accepted by the party?
if you are only accepting the agreement to act as a valuer, so there is no need for stamp paper at all. They can write you an offer letter saying that the company is pleased to appoint you as a valuer. Your scope of work will be like this, and you will be paid a fees of rupees like this. And in continuation of that letter, if you convey your acceptance by a separate email or a letter in whatever way you have agreed to, so agreement comes.
Will it stand in court of law?
It will stand in the court of law, 100%. For example, some of you might have joined an employment at some point of time in your life, and the employer gives you a letter that the company is pleased to offer you the post of, say, deputy manager or assistant manager or a manager, and these are the terms and conditions, and you will be paid salary like this, and you say these terms and conditions are acceptable to me. Agreement came into being.
Sir, one question.
Yes.
One question.
Yes.
Yeah, actually, in case of an agreement renting the property, in that case, suppose we are not just drawing the agreement.
Yes.
We are drawing the agreement, but not registered in the court.
Let me answer you right here. I have understood the question.
Yeah.
So since this is a agreement relating to transfer of immovable property, so even renting, leasing, licensing is also one of the kinds of the transfer under the Transfer of Property Act. And in case you are entering into and not registering it, then such an agreement will not be enforceable. However, some state governments have this registration and stamp duty is a state subject, and some of the state governments have issued a general exemption saying that any rent deed involving a period of less than 11 months or 11 months or less does not require registration. So if such a notification has been issued, then sorry, just let me complete the sentence. Then you don't have to get it registered. Can I go further?
That means in that case, in the court of law, any objection is there, it will be difficult to just settle.
Yes. In case, say, you give your house on rent, say for a period of 3 years, do not get it registered, and even after 3 years, the tenant does not vacate it, and you go to the court of law, the court will say, gentlemen, you have saved stamp duty, you have evaded payment of the stamp duty, so you don't give you any relief. This particular piece of paper that you have brought, even though it is in writing, it is not enforceable. You go home.
Thank you.
Okay. That means in order to enforce the, or it could be the other way out also, that you might have given your property on rent for a period of 3 years, and after 1 year you want to vacate that, and there might be some clause relating to vacation by giving 2 months notice or 1 month notice. You give a notice, tenant doesn't vacate, you go to the court of law, okay, and tell the court that according to this paragraph in the agreement, I want to get my property evicted because I want to use it as the residence of my son or myself. The court will say nothing doing. You have evaded payment of stamp duty, so it's not enforceable. Okay, can we go further?
Yeah.
Yes, sir.
Okay.
Sir, one small doubt.
Yes, please.
Do I need to hire an advocate to file such counter?
Not necessary. Not necessary. In case it is your own case and you want to contest it, even in the court of the judicial magistrate or in the high court, if it is in your own case, you can appear it. There is no restriction. There is no legal need of hiring an advocate. But in case you want to represent somebody, say you want to represent your friend in a high court, but there you cannot make a representation unless you possess the prescribed qualification, and the prescribed qualification is LLB and registration with the Bar Council of India. Like that, in case you know little bit of a medication, you can give it to yourself, your wife and all, nothing will happen. In case even if she dies, that nobody will be here to sue you. But in case you want to prescribe medicines to a common people or to somebody, you must possess a medical qualification, right? Otherwise, it will be quack, and the government will come and arrest. In case I do not possess the prescribed qualification, that is MBBS and above, so I cannot prescribe medicines to anybody. Can we go further?
Sir, I have a small query.
Yes, sir. Yes.
Yeah, there are if there are agreements like MOU, joint venture agreements, or a letter of intent, with all the 5 points, 5 elements of the contract. So can they be termed as contracts, or is it only remain as an agreement?
That I am going to explain to you. So far, I have these 5 elements I am going to take up with you at a much greater length.
Sure.
Now, it's a lot of more interesting things are there. You will find a lot of other interesting things, and it will provoke a lot of discussion. I'm quite encouraged with your participation, but let's also carry on with a little bit of a syllabus. Is it okay?
Sure.
Yes.
Let me assure you, a lot of further interesting stuff is there in the subsequent slides.
What is the difference between? No, one thing. What is affidavit, sir? That is different from. What is the affidavit?
Hello.
What do you mean by affidavit?
Can we go further?
Yes, sir.
Are you hearing me?
Yes, sir. Yes, sir.
Am I audible?
Yes, sir.
Yes, sir.
Sir, fellow participant is asking about affidavit. Difference between affidavit and agreement.
Sandeep ji.
Sir, you are audible.
Sir, you are audible.
Hello.
Hello. Yes, sir.
You are audible, sir.
Hello. So my question is, what is affidavit?
Am I audible?
Yes, sir, you are audible.
Perhaps
You are 100% audible.
You are audible, sir.
Hello.
We are hearing Ramaswamy.
You are audible, sir.
Hello.
You are audible,
Hello,
sir.
sir, you are audible, sir. Please go ahead.
Hello.
Yes, sir, you are audible, sir. Please go ahead.
Sir, you are audible. 100% you are audible.
Connection out of connection तो नहीं हो गए हम लोग.
Sir, you are audible. Please go ahead. Mr. Sandeep ji. Sandeep sir, coordinator Delhi, Sandeep sir. Coordinator Delhi, Sandeep sir. Sandeep sir.
Hello.
Rajesh sir, you are audible. Rajesh Khanna sir, you are audible. Please go ahead. Sir, you are audible. Please go ahead.
Hello. Are you able to listen?
Rajesh Khanna sir, we are able to listen. Please go ahead.
Am I audible?
Yes, we are hearing you. It is audible. You are audible, sir.
Yes, sir, you are audible, sir.
You are audible, sir.
Would you hear me? Would you hear us?
हेलो. आ रही है मेरी वॉइस, लेकिन स्टूडेंट्स का रिस्पांस नहीं आ रहा, पार्टिसिपेंट्स का रिस्पांस नहीं आ रहा. मेरे को लगा कि कहीं आर यू एबल टू लिसन टू मी? वीडियो की तरफ से बात करना जरा.
एक्चुअली प्रॉब्लम है उनके साथ.
Yes, sir, you are audible. You are audible.
Hello.
You're audible, sir. You're audible. Yes.
Audible,
You
sir.
are audible. Go ahead.
You're audible. Go ahead, sir.
Go ahead. Go ahead. Go ahead, sir. Go ahead.
His speaker is not.
हेलो. मेरी आवाज आ रही है?
He is not.
आ रही सर, आ रही है.
मोबाइल पे तो आ रही है, लेकिन मेरी आवाज
आ रही है सर.
में भी आ रही है
सर, आ रही है. Go ahead.
ना, नहीं आ रही.
We need intervention of Sandeep sir. I think.
खुराना साहब का स्पीकर ठीक नहीं है, something.
हाँ,
Sandeep साहब is expected.
मैंने मुंह से ऑडियो से नहीं आ रही।
उनका स्पीकर ऑफ हो गया है।
स्पीकर ऑफ हो गया, स्पीकर।
एक सेकंड में देखता हूँ, स्पीकर भी ऑन है।
फिर हमारी साउंड आ रही है सर आपको?
एक बार दोबारा ज्वाइन करूँ, मैं दोबारा ज्वाइन करता हूँ।
हाँ सर, हाँ वो ठीक रहेगा। चाय पिलाओ भाई, चाय पिलाओ।
सब आपको अकेला, हम पूरा लोगों को, ऑल ओवर इंडिया पार्टिसिपेंट्स।
सर आपके लिए मैं इधर चाय बनाओ, सबके लिए चाय।
Virtual.
Yes, all are welcome in the group. Let us form a group. There I will invite everyone for the tea.
मैं वरीड हूँ। अब आ रही है देख।
Yes sir, आ रही है।
सर आ रही है।
Sir, you are audible. No problem.
Yes, yes.
बढ़ा दूँ, ओके। नहीं, लेकिन अभी तक तो अच्छी, बहुत बड़ी अच्छी आ रही थी।
You have been informing you, sir, but you are not audible.
खुराना जी,
हैं?
are you getting the voice?
ना।
We are able to listen you, sir.
Hello.
Yeah, go ahead, sir. Go ahead.
उनको फिर बोल दो अपनी तरफ से कि क्वेरी जो है वो चैट बॉक्स में डाल दें, तो उसको मैं आखिर में बाद में पढ़ लूंगा। लेकिन मेरे को कॉन्फिडेंस नहीं आ रहा बीच में, जब तक कोई बात करता ना, मेरी आवाज, मेरे पास आवाज क्यों नहीं आ रही?
सर आपको आवाज आ रही है अभी सिस्टम से? ओके ओके फाइन सर। हेलो सर, अभी आपको वॉइस आ रही है खुराना जी? सर आपका माइक म्यूट है, कुड यू प्लीज ऑन योर माइक? खुराना जी, सर आपका माइक म्यूट है।
सर खुराना सर को तो आवाज ही नहीं जा रही, तो कैसे सुन पाएंगे? तो उनको रिंग करना पड़ेगा, आई थिंक।
उनसे बोल देना पड़ेगा, थ्रू कोऑर्डिनेटर बुलवा देना पड़ेगा संदीप को।
Yes, by phone only we need to. Sandeep sir is requested to contact by phone and give information.
Now, sir, I am able to hear all of you. Are you able to hear me?
Yeah, it's very
now.
Yes, sir, please go ahead.
Yes, sir, please go ahead, sir. No problem.
Okay, thank you. Thank you very much. Okay, friends, I think we have had a good amount of very interesting discussion, to an extent that even machine perhaps got tired. So I don't know what problem it happened. So we are not able to hear each other. Now you are able to hear me? Hello.
Yes, sir. Please.
Yes, sir.
Yes, sir.
Yes, sir.
Yeah, very clearly.
Very
Okay.
clear.
Good. So friends, we start where we stopped at that time. I was trying to take up with you certain essential elements of contract, and these are the essential elements of contract. That means there has to be essential elements of a contract. That means there has to be minimum 2 parties. Then there has to be offer and acceptance, and there should be concurrence of the offer and acceptance. Then we come into an agreement. then there should be free consent of the parties, then there should be intention to create legal obligation, the party should be competent to contract, and then there should be lawful consideration, lawful object, and such an agreement should not be prohibited under any law. So one by one I will take up. So I have already taken up with you first two things, and now we take up when is the consent free, when is consent not free. There should be free.
Sir, I request to be more fast so that other topics are required.
Yes. Don't worry at all. But at the same time, I did not want to silence all of you. So they want to build up certain kind of a trust and communication. So long as we have succeeded in doing that, and now let us take up one by one as to when is consent free, when is consent not free. Section 14 of the Indian Contract Act provides that consent of the party is not free if it is obtained by coercion, undue influence, fraud, misrepresentation, and mistake. So I will try to be a little faster now, but still in case you have any doubt, please ask me. What is coercion? Coercion is an action or a practice of persuading someone to do something by using force or threat. Say you just put a gun on his neck and say either you sign this agreement or I will shoot you. That is the use of the word coercion. Or when you threat somebody that you will commit something which is prohibited under the Indian Penal Code, or you use a threat of doing something which is prohibited under the Indian Penal Code or something, then it is a use of the word coercion. If you obtain somebody's consent either by threatening him or by unlawful detention of his property or threatening to detain his property, then there is a coercion, which means in literal Hindi word, किसी से अब जबरदस्ती कोई चीज साइन करा लेंगे और उसकी कंसेंट जो है, उसकी एग्रीमेंट जो है जबरदस्ती करा लेंगे, either by use of a force or threatening to use of a force. अगर वो साइन कर भी देगा आपका एग्रीमेंट, such an agreement will not be enforceable in any court of law. Is it correct?
Yeah.
कोई आपके सामने आपके घर में आए और आपसे जबरदस्ती चेक पे साइन करा ले, and you have signed it and you have also signed some agreement in his favor, at the first possible opportunity you should back out from that contract. So if you have already signed a check under a threat or under a fear of a threat, somebody trying to say murder you or somebody trying to hit you with something, and you have signed some agreement, immediately you should back out. You should be able to prove that I have signed this agreement by use of the coercion. Coercion means jabardasti, or practice of persuading somebody to do something by force or threat to use force. In such cases, there will be no agreement. Like that, if
Sorry, it should be.
Yes.
That means it should be immediately informed to court.
Yes.
That this is a case of coercion.
Yes, somebody has got this agreement signed from. You say some your neighbor got some agreement signed whereby that agreement relates to leasing of your property or relinquishment of your right to some property. In such cases, immediately you should lodge an FIR with the police saying that this man has forced me to sign this paper and this man may be directed to return that paper to me. So lodge an FIR, then police will help you to take a criminal action against that fellow. Okay, like that, if somebody has.
Sir, I have one question.
Yeah.
Sir, suppose the police is hand in gloves with the person who is forcing you for caution. What is the next remedy?
Next remedy is you meet a senior officer in the police. Say if you have lodged an FIR with the SHO, and
that's what I told you. If all, for example, a politician, if all are hand in gloves.
Everything cannot be, but if you put it in writing, later on you can also prove it in the court of law that the first possible opportunity I have lodged an FIR, and that FIR you can show it in the court of law also. Okay.
I agree with you, but the ground reality is quite different than actual, sir.
That I agree.
I think registered letter will also do.
No, even you can get it signed from there. You can take it to any police station. You take a letter, 2 copies, and at the reception you hand over. That fellow will put a stamp and give it to you. It is your acknowledgement. You can also send it by registered post. Okay.
Do it online.
And another thing is, see, there is a law which prevails, and there are certain difficulties in seeking remedy under the law. Those difficulties are always there. Say, for example, there is a law that anybody who commits a murder shall be executed, shall be deprived of his life, or he will be executed, or he will undergo life imprisonment. But if you see how many murders are taking place, but how many people we are able to really execute, so that gap will always remain. Okay, but in all the more, law is there. We should not feel frustrated that law nahi hai, law hai. Okay.
Sir, only one doubt. One doubt.
Yes.
Sir, इसमें कोई टाइम फ्रेम है?
आपकी आवाज फट रही है, थोड़ा धीरे से बोलो।
ये जो मान लीजिए किसी ने ब्रीच किया, उसने फोर्सफुली कुछ साइन कराया, तो कोई टाइम फ्रेम है लीगली कि इतने दिन के अंदर या इतने घंटे के अंदर उसको ही लॉन्च करना है कंप्लेंट को?
It says it depends upon the court. You should do so within a reasonable time. यदि ये थ्रेट करते हुए आपको उसने बेहोशी की दवाई दे दी और उसकी वजह से आप 5 दिन बेहोश रहे और उसके बाद आपको होश आया, so court will determine under what circumstances this coercion was used. And is right?
Yeah.
Okay. And what kind of an agreement you have signed? How long it took you to understand the consequences of your signing this? So those things court will take into consideration. But law says that it should be done within a reasonable time. Okay. Then undue influence is a contract is said to be induced by undue influence, where the relation subsistence between the parties are such that one of the party is in a position to dominate the will of the other. When is a party dominate the will of the other? Say there is a parent-child relationship. If the parent influences the child to something which is not in his interest and which child doesn't want, so he can always say parents ne mere se jabardasti sign kara liya. They are in a dominant position. Like that, there could be a relation between doctor and a patient, and the doctor may dominate because doctor normally dominate the will of the patient, and in case he takes a unfair advantage of his being a doctor. In such cases also, the patient who has signed the agreement more in favor of the doctor can always back out by making an application in the court of law. Like that, there could be a situation between religious guru and the disciple. Many times these religious gurus are very powerful. They make the disciple to renounce everything in favor of the mutt or trust or in their favor. In such cases also, the person, in case the person has signed the agreement under the undue influence of another person, and that another person has misused his position to take unfair advantage out of his disciple or client, even advocate and client also, sometimes these kind of a undue influence can be there. Fraud, you know that anything is done fraudulently. In case fraud means and includes any of the following acts committed by the parties, that is which involve cheating or which might involve deception, or which might wrongly telling something with a intention not to perform it. So there could be any of these 5 elements of fraud. Any suggestion as a fact of which it is not true, telling somebody that you have a 5 horsepower motor, you want to sell it, actually it is a 3 horsepower motor, and by deceptively you persuade another person to buy it. So that is a question of a fraud. Like that, active concealment of a fact which is not there. You tell another person that this is a good fruit or this is a healthy animal. You are wanting to sell a horse which is a sick horse, but you tell the buyer that it is not sick, it is a perfectly healthy horse. So in such cases there is a fraud. Like that, promise made without any intention of performing it, or any act fitted to deceive. So if in case these kind of things are there, any person whose consent has been taken by fraud can back out of the contract. Sometimes silence could also be a fraud. Say the other party asks you whether it is a healthy horse, you just keep silent. I presume that it is a healthy horse, and you also do not say anything, such a silence will be presumed that you are giving your consent and you are indulging into fraud. Like that, there could be misrepresentation. Misrepresentation means behkana, todna marodna, giving a false or a misleading account of the nature of something. Misrepresentation means any positive assertion in the manner not warranted by the information. You tell somebody, say you go to a shop and the shop wala says that this cloth I am selling has a pakka color. Its color will not fade. Now question arises whether the shopkeeper is aware that the color will not fade. If the shopkeeper is aware that this particular garment that he is selling will fade in color, if he is aware, then it will fall into the category of the fraud. But if it is not aware but still tell, knowing or not, whether innocently or ignorantly, he is telling that color will not fade and later on color fades, then this will be question of a misrepresentation. Any breach of duty which without an intent to deceive gains an advantage to a person. Say I had to, it is my duty to deliver you a good lecture, and in case I commit a breach then and do not deliver you a proper lecture, it will be question of a misrepresentation. Causing, however innocently, a party to an agreement to make a mistake as to the subject matter of the contract also comes under the category of a misrepresentation. So whether it's a misrepresentation or a fraud, it is a matter of degree. Whenever you make a statement, a wrong statement, even if you make a wrong statement innocently, but the statement turned out to be wrong, it will fall into the category of the misrepresentation. But if you knowing that such a statement you are making is false, in order to deceive another person, it will be a fraud. In the case of a misrepresentation, the parties whose consent is taken by misrepresenting the facts, they can only back out the contract and ask for the compensation. But fraud by itself is prima facie a criminal act. A person can also, under the criminal procedure code, action can be taken against the person who commits a fraud. Then like that, there could be a mistake. Mistake is an error, a gaffe or a slip up. When you make a mistake, you have done something incorrectly. When does mistake come into being? Mistake could be a unilateral mistake. That means one party is correct, other party is do a mistake, or both the parties may be in mistake. How both parties can be in mistake? You think that you are selling your mobile phone A, you have two mobile phones, you want to sell one of these. You think that you are selling mobile phone A, other party thinks that it is buying mobile phone B. So there is a mistake on the fact part of the both the parties about the subject matter of the contract. No contract will come into being. So in such cases, like that, there could be a mistake, unilateral mistake. Unilateral means one party is in a correct position, but other party is mistaken. In such case, normally the contract will come into being, but there are exceptions. Exceptions are as to the person with whom you are entering into a contract and the subject matter about which you are entering into a contract. Say, for example, I receive an email which is signed by some gentleman N. Modi, and it wants, for a while, just understand that I am a tailor and somebody has sent me an email. He wants me to stitch a suit for him, and N. Modi is signed below that. I think that I am being asked to stitch a suit for Narendra Modi. So I will be very happy, will quote a much less price, will also be willing to do it free. At the time when I am signing the agreement, I get to know that this N. Modi meant Nirav Modi, not Narendra Modi. So in such cases, there is a mistake about the person with whom I am entering into a contract. Many times these kind of a mistakes could also be, you think that you are entering into a contract with a company for leasing of your house, say with State Bank of India or with Canara Bank, for the resident of that person who will be living or employee who will be living. But later on you realize that it is the employee himself is going to enter into an agreement. You want to let it out to the company lease, but don't want to give it to the individual lease. In such cases, there could be deception or the mistake about the person with whom you are entering into a contract. So two types of things. एक तो subject matter of the contract and the person with whom you are entering into contract. Even if about these there is a unilateral mistake, single person's mistake, no contract will come into being. Then there could also be mistake about the law. In case you are entering into a contract in India to which the Indian law will applicable, ignorance of the Indian law is no excuse. So tomorrow you cannot say, sir, you enter into a contract with a minor and later on you know that it is not enforceable against the minor, then you cannot say, sir, I was not aware that the contract entered into with a minor was not enforceable. So you will be liable for all the consequences against such contract. But in case you enter into a contract which is subject to law of some other country, say application of US law or UK law, that will be treated in the same way as if it was mistake as to the subject matter of the contract. Now friends, we have taken up with you when the consent is free, when the consent is not free. So a consent is free when it is not obtained by coercion, fraud, misrepresentation and mistake. If such a thing has not been there, then the consent will be free. Next important element of the contract, essential feature of the contract is that you should have a consideration. Consideration means whenever quid pro quo, something in return. When you promise to give something, you must get something in return. And that something given and taken is called quid pro quo or something in return. This is also called consideration. Something received need not be in terms of money. As stated, if there is a decided case on this particular subject, it could be some right, interest, profit, benefit accruing to one party, or it could be some forbearance, detriment or loss or responsibility taken by some other party. So you may be willing to pay money provided the other person do not open a shop in competition with your shop. In such cases, what other person is giving you is a forbearance, detriment, loss, or he is taking up a responsibility not to open shop, whereas you are giving him certain money, or you might be giving something in kind. And this consideration need not always be in money. It can be in kind also. You may exchange your bicycle in return for, say, something, a donkey. So in such cases, you are giving bicycle, other person is giving you a donkey. So there is a consideration, even though the considerations are in both sides, there are kinds only. Regarding consideration, friends, one thing I want to tell you, while there has to be consideration and there is a rule that no consideration, no contract. But a little later, I will also tell you the exception of the exception to the rule. But before that, I want to give you a formal definition of the consideration. When at the desire of a promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act, abstinence or promise is called consideration for a promise. So here I would like to tell you, has done something or abstained from doing something. That means consideration could be past. Somebody might have done something to you in the past, and in return, you are liable to give something now. So somebody might have sold the property to you on credit, and in return of that, you may have to pay the amount in future. So that's also there. Or it could be at the time of entering into contract itself, somebody gives you X item, you give him Y item. So it could be a present consideration, or it could be future consideration. While you may do your part of the contract now, the other party may agree to perform its part of the contract at some future date. So such act, abstinence or promise is called consideration. While there is a rule that there has to be consideration in all the contracts, and every contract must be supported by a consideration. And consideration is something in return. It can be in cash, kind, or it can be abstained. It could be past, present, or future. An agreement without consideration is not enforceable in any court of law. However, there are certain exceptions to the rule, which I will take up. Before I take up those exceptions, let me also tell you, consideration need not be adequate. Sometimes it could be inadequate consideration, or there is no way for the court to determine that at what price you should sell your old car, or at what price you should buy a house, or at what price you should sell a donkey or buy a horse. So it is for the parties to decide the consideration. But so long as there is a consideration, that there will be a contract, and if there is no consideration, there will not be contract. But there are certain exceptions to the rule. Exception to the rule are agreement based on natural love and affection. In case by natural love and affection, you transfer your entire property to your spouse, son, daughter, or out of natural love, then such an agreement will be enforceable even though nothing passes from your relative to you, provided such an agreement is in writing. So agreement is based on natural love and affection, and the agreement is in writing and registered. In such cases, even though no consideration passes, agreements will still be valid. Like that, promise to compensate for gratuitous act. Gratuitous act is somebody might have done you some favor. Say, I give my own example. My house was on fire and lots of neighbors came with their buckets full of water and they helped me in extinguishing the fire. When they were extinguishing, they were not expecting anything in return from you, but they have done their as a good neighborly duty to me. Whenever fire was extinguished, I tell those gentlemen, thank you very much. So you have incurred a lot of expenditure from your side. I agree to compensate you for whatever good you have done to me. In case I make such a promise, at the time of making of such promise, no consideration is legally liable to be transferred from those people to me. But since I am making a promise to compensate for a gratuitous act, such an agreement will be enforceable. Like that, promise to pay time bar debt. Time bar debt is some money was recoverable, but payable, but it was not paid. I had not paid, and more than 6 years under the law of limitation have passed. Now other party cannot recover it from me. But despite the fact that other party cannot recover it from me, and I still promise them, don't worry, gentlemen, even though it's a time bar, I still agree to pay you. In such cases also, even if no consideration is passing from him to me, agreement will still be enforceable. Like that, agency agreement. If I appoint somebody as my agent, or somebody appoints me as his agent, no consideration is required. Like that, completed gift. In case you make a gift and gift is completed, say if the gift is of a movable property, the delivery is already done, and the person to whom the person to whom gift is given, he has already gone. Later on, you cannot tell that gentleman, so I have gifted you this property, but you have not given me anything, so I want to back out from the contract. You cannot do so. These are the 5 exceptions, so where the contract will be enforceable even if they are without consideration. But other than these 5, in case there is no consideration, then contract will not be enforceable. Then next I want to tell, okay, not only that, there should be not only that there should be consideration. The consideration should also be lawful. Lawful in the sense that I will take up with you when the consideration is lawful. That means such consideration should not be forbidden by law. If I agree to pay a friend X, say 20,000 rupees, provided he beats up my neighbor or my competitor, or he puts a fire to the house of my neighbor or to my enemy. In such cases, whatever I pay, फिरौती जैसे देना होता है, so I pay him something to somebody X amount of money and tell him that you eliminate this fellow or beat him up or hijack him or kidnap him. In such cases, paying this kind of a firoti or a amount is forbidden by law. Like that is of such a nature that if permitted, it would defeat any provision of law or is fraudulent. So in such cases, consideration is not lawful. Like that, if it involves or implies injury to a person or a property of another person, so it is not a lawful consideration. If the court regards it immoral or opposed to public policy, in such cases also consideration will not be lawful. In each of these cases, consideration or the object of agreement is said to be unlawful, and every agreement for which object or consideration is unlawful, such a contract will be void. Say for example, you pay somebody 50,000 rupees, telling him that that person who is getting the money, he should poison your enemy, and if he takes the money and later on he doesn't poison, or he promises to poison and actually poison and later on ask come to you for the taking of a money, either way this agreement will not be enforceable. Not only consideration but object should also be lawful in the same manner. While consideration is, there is a slight difference between consideration and the object. While the consideration is what immediately passes between the parties, object is what is the overall purpose of entering into a contract. Say for example, you agree to construct a outhouse for me. You construct a house, you are a contractor, I am the contractee, I agree to pay you a money. But if both of us agree that you should construct a outhouse near Kandla, and I want outhouse should be so strong that I want to use it for smuggling activity, for those ships would be coming, and I will be using it for the purpose of construction of the outhouses to store the smuggled material. In such cases, while you are agreeing to construct and my paying you the money, both our considerations are lawful, but the overall purpose for which we are constructing the outhouse is an object is unlawful. In such cases, contract will be void, unenforceable. So friends, there are certain contracts which are unlawful and there are illegal agreements. Unlawful means they are in the nature of void agreement. They are not enforceable in any court of law. For example, any agreement to have live-in relationship. In case some young lady has a live-in relationship with her friend, and as a result of it, in fact, there was a case of some air hostess staying with a pilot, and during the course of the live-in relationship, that lady turned pregnant, and then she applied to the court of law asking for that the pilot should be forced to marry her. And the court said, was there an agreement to marry? She said no, and she could not prove that there was an agreement to marry. So in such cases, court could not give any relief. While live-in relationship as such is not illegal, but at the same time, if some consequences turn out of this kind of a relationship, court will not refuse to give any relief, and such an agreement is not illegal, but it is unlawful. But likewise, if somebody enters into an illegal relationship, illegal agreement on the other hand is not only void between the immediate parties, but has further effects of collateral consideration, that it becomes tainted with illegalities. That somebody wants to enter into, say, something which is prohibited by law. In such cases, whatever considerations are given and taken in pursuance of fulfilling that objective of the agreement, that will also get tainted with illegality. And not only that, contract will not be enforceable. Parties which enter into an illegal agreement, they will also be subject to penal action under the Indian Penal Code. Then friends, there are some slight difference, as I said, between the void agreement and the unlawful agreement. Any agreement for which the court does not give any relief, so they are unlawful agreement. But the Indian Contract Act under the different sections prescribes that certain agreements shall be not enforceable with any court of law. Their specific prescription is there. For example, agreement entered into with the incompetent parties. What are the incompetent parties? And when is the party competent? That means a party, in order to be competent, must be major according to the law to which it is subject. The party should not be of an unsound mind, and the party should not be debarred under any law from entering into a contract. If any of these three elements are there, then the party will be incompetent to contract. And if anybody, XYZ, enters into contract with a party which is incompetent to contract, such an agreement will be void agreement. Like that, agreements made under the mutual mistake of facts, I have already told you that you think that you are selling your mobile phone A, the buyer thinks that he is buying B. So in such cases, agreement will be void. No court relief will be there. Agreement, the consideration or object of which is unlawful, so I have already explained it to you. Agreement or the consideration or object of which is partly unlawful, they will also be void. Agreement without consideration or void, except those 5 exceptions which I have taken up with you. Agreements in restraint of marriage. If any of us enter into an agreement with other person that, okay, give me 20 lakhs of rupees, I agree not to marry during my entire life, because marriage is a right, as good as right to life. It's a fundamental right. So anybody who enters into an agreement that he will not marry during the whole lifetime, so the party with whom he is making the agreement will not be able to enforce such agreement. Like that, agreement in restraint of trade. Say somebody gives a commitment or an undertaking or a bond that he will not during his whole life engage himself into any trade, commerce or activity. In such cases, such agreement or such commitment is not enforceable. But friends, here some reasonable restriction could be there. As I gave an example that if the partners are parting and one partner takes a goodwill, then the other party can impose certain reasonable restraint about against which he has taken a goodwill. Say, for example, you join an employment, an employer, and give a bond to the employer that you will not leave the employer during the whole of the lifetime. In such cases, there is an agreement in restraint of a trade. There is a slavery kind of an agreement. There is a bondage. It will not be enforceable. But before joining an employer incurs upon you some huge expense. Say it makes you undergo some MBA or some very advanced training for which employer incurs say 10 lakhs of rupees. Employer can impose a reasonable restraint that in case you do not work up to say 5 years, and in case you want to leave the job before 5 years, you will be liable to compensate the employer about the cost of expenses. So this kind of a restraint should be there, but outright restraint is opposed to public policy, will not be enforceable, will be void. Agreement in restraints of legal proceeding. You want to enter into an agreement with somebody, and at the same time, one of the paragraphs says, irrespective of whatever violation may be taken by the other party, the aggrieved party will not approach any court of law. Is this kind of a restraint is there? It is not enforceable. It has no value at all. But there could again be a reasonable restraint in case there is a dispute or difference between the parties. Party will take resort to say arbitration or conciliation or discussion or negotiation. This kind of restraint can be there. Like that, agreement, the meaning of which is uncertain, agreement by way of a wager, agreement contingent upon impossible event, agreement to do impossible acts, they are all void agreement. They are not enforceable in any court of law. There could also be voidable contract. Voidable contract means any person who enters into contract and whose consent has been taken by any of those 5 elements, coercion, undue influence, fraud, mistake, misrepresentation, etc. The person whose consent has been taken by consent is not free, the contract is voidable at his option, but not at the option of the person who has taken the consent through fraudulent means. So this also you have to keep in mind. Then friends, contract could be of 2 kinds. There could be absolute contract and there could also be contingent contract. Absolute contract means where the rights and obligations of the parties are decided at the time of entering into contract itself. They are called absolute contract. And sometimes the contract may be entered into and which are dependent upon happening or non-happening of certain uncertain event. And those contracts are called contingent contracts. For example, I promise to sell you certain goods which are on high sea on way from UK to India. And the contract is, in case the goods arrive safely, I will sell these goods to you at X price. So there is a contingent contract. In case the goods arrive, you can enforce delivery of the goods from me. I can enforce the recovery of money from you. But in case the goods are destroyed on the way, they are drowned or they are spoiled beyond recognition, in such cases, neither you will be able to enforce delivery from me, nor I will be able to enforce recovery of the money from me, because the basis of the contract itself was contingent upon the safe arrival of the goods to India. Now, friends, I have taken up almost all kinds of agreements and the process of entering into an agreement. Now, once the agreement is entered into, what should we do? The parties who have taken up their obligations under the contract and the parties who have acquired their rights, particularly those who have taken up the obligation, they should perform their part of the agreement. Performance of the contract take place when the parties to a contract fulfill their obligation arising under the contract within the time and in a manner which is prescribed under the agreement. Say, in case you have entered into a contract to construct a building, so you should construct a building according to the specification, according to the terms of the agreement, and the contractee should pay you the money according to the different stages of payment that was prescribed. Like that, Section 37 lays down that the parties to a contract may either perform or they should offer to perform their respective promises. Say, in this example, in case you have agreed to construct a house and you come with the material, labor, mason, carpenter to construct a house, I refuse to deliver to you the land where the house is to be constructed. In such cases, you have already offered to perform your part of the contract. I have committed a breach in not allowing you to perform your part of the contract. Then you can always sue me for damages that has taken place to you because I have committed a breach. Who should perform the contract? Either promisor himself should perform the contract. Then contract can also be performed through an agent or a legal representative. In case there are more than one promisee, then the contract can be performed by any of the promisee. Then the time, place, manner of the performance should be such as has been prescribed in the agreement. So one of the way of now, how do the contract get discharged? Because entering of the into contract is easy. Sometimes performance becomes difficult, and in case the performance is there, there could be some difficulty. How do the contract come to an end? One of the way of contract coming to the end is by performance or offering to perform. So contract comes to an end. Like that, by mutual consent, as the parties entered into contract, they can also end the contract. They can also discharge the contract, discharge each other. Okay, we have entered into contract for construction of a house. Then landowner may say, please do not construct it. I have changed my mind. And the contractor may say, okay, don't worry, I have no objection. So in such cases, they may agree not to penalize anybody. They may agree to discharge the contract. Like that, if the contract becomes subsequently impossible means it could be legal impossibility, it could be physical impossibility, or it could be some kind of an act of God. Say you might have agreed to host a party at a particular place. Say you might be a Shamiana holder, might be a place where you might be running a catering unit. You have agreed to host a party. Then law has been passed that now not more than 50% or 20% can assemble at any point of time. So the act has become legally impossible. In such cases, contract also will get discharged. Like that, operation of law, there could be law might change in such a way that doing of that particular activity becomes difficult. Or some of the party may breach the contract. In such cases, the contract will come to an end, but the party which has committed a breach, that party is liable to compensate the party which is not in breach. What are the remedies available to the party? Yes, please.
Sir, Mahendra.
Yes.
Sir, in the government sector,
yes,
of course, it has to be tendered, but in emergency, to obtain certain material, we take 3 to 4 quotations. Secret quotations. So, is there any such act in contract?
It's a government general financial rule of the Government of India, which prescribe that every department which uses the government money, they should get the best value for the money. That person who is acting on behalf of the government, they should not misuse the fund. They should not indulge into over invoicing. They should not end up paying more money. This is like when your wife wants to buy a sari, she goes to one showroom, asks for the price, asks for the quality. Then she may or may not like, go to another shop, again ask for the price, ask for the quality, third shop. Sometimes she feels that, oh, the previous shop was selling it better. She comes back to the previous shop and then buy the sari. Obtaining 3 quotation is just like that, exploring of the market so that you get a best value for the price that you are paying. And the best value
My
can,
submission is, sir,
best value
my
can,
submission is any stipulation of rule section.
Hanji?
Any section states that.
General financial rule, if you open, the opening sentence of the general financial rule is you should use the government money in the same manner, with the same level of diligence as you will do in using your own money. Right? Opening sentence of the general financial rule says like this. And there are different provisions also provide. For example, Government of India has provided that any contract having a value of more than 250 crore should have a international competitive bidding. Very recently, they have waived off that all contracts having a total bid price of less than 250 crore or up to 250 crore, the companies or departments, or they can go for, or even defense department, they can go for only domestic competitive bidding. These kind of regulations are made with purchase manuals of different departments of the Government of India. They prescribe that. Okay. Can we go further?
Yes, sir.
In case one party commits a breach, they are not performing, what the other party should do? Other party can also rescind the contract. For example, in case you are not constructing a house for me, I can also rescind the contract. I can refuse to make payment to you. So that's one relief or a remedy available to the aggrieved party, जो के breach में नहीं है. Then the aggrieved party can also file a suit for damages, make an application to the court of law and ask for the damages. Suit for quantum merit. Quantum merit is as much as performed. Say you hire an auto to go to the airport. On the way, auto gets a breakdown. It is unable to start. What do? You pay the auto wala almost pro rata kind of a price and then proceed further. Like that, in the case of contract also, if you have agreed to construct, say, 3 towers for a particular contractee, and by the time you contract 1 or 2, and somehow performance of the remaining construction of the remaining towers becomes difficult, so you can ask the contractee to compensate you for whatever work you have done. Like that, suit for specific performance in case of.
One more.
Yes, please.
One more small doubt.
Yes, sir.
Just now I informed that for rental agreement up to 11 months need not to be registered. Okay.
Some states have.
Is there any
financial limit? Yeah.
Is there any financial limit which need not
No,
to be registered?
there is no financial limit in that. Because
Okay.
in the Transfer of Property Act, it is written any transaction relating to immovable property which has a value of 100 rupees or more, that requires the registration. But since the Transfer of Property Act falls in the jurisdiction of the state government, some of the state government have issued a notification waiving of that requirement up to 11 months. Okay.
Okay, sir. Okay.
Okay. Then you can also file a suit for specific performance of the contract. Say, for example, you have agreed to buy a house on, say, first floor, facing a swimming pool, or facing a garden, or facing a seaport. And in case you want that any money compensation is not good enough for you, in such cases, you can. In such cases, you can apply to the court that they should order the defaulting party to make a specific performance of the contract. Like that, suit for injunction. Suit for injunction is a negative part of the contract, which means the court can give a kind of a stay order that stopping that person from performing what he has performed for anybody else, which he has agreed to perform it for you. There are certain terms under the Indian Contract Act: novation, recession, alteration of the contract. So these I would like to take up with you. Novation is an act of replacing an obligation to perform with another obligation. Say, for example, you have entered into a contract for leasing of a house. Later on, you replace that lease deed with a sale deed. You tell the landlord, sir, I have been living in your house, paying you rent for so many years. Now I want to buy it. Are you willing to sell? And he says, yes. In case he is willing to sell and you enter into a sale deed get the place of the old agreement. So you get a superior right over the inferior right. So this process is called novation. Replacing an obligation to perform with another obligation, or adding to an obligation to perform, or replacing a party to an agreement with a new party. So you have entered into an agreement to construct, and now you want to go to United States. You tell the contractee that instead of I constructing, rest of the construction will be done by my friend. But this novation can be done by mutual consent of both the parties. The next is recession. Recession is an equitable remedy. I have just explained to you. In case one of the party is unwilling to perform, then you can also rescind your contract. That means you can also break the contract. That means in case you are a victim of the other party not performing, you can also stop. You can also unwind the transaction. You can this is done, which may bring the party as far as possible back to the original position. Then alteration of the contract, you can also alter any terms of the contract you have entered into. Alteration could be reduction of some of the part of the work which is not required, or some adding of a new work. So this kind of alteration can also be done by mutual agreement. All these novation, alteration of the contract, and is done by the mutual consent of the party. But recession is a kind of a fait accompli. Fait accompli means once the party, one party is not performing, the other party can also refuse to perform, and the refusal to perform by the other party as a consequence of the first party not performing is recession of the contract. So friends, now I want to take you up to special kind of a contract. Contract of agency is very simple.
Sir. Can you please explain novation of contract again?
Novation is replacement of one contract with another contract. Replacement. Novation means replacement. So I gave an example that you have entered into a contract for lease of a house and you are living on that house. And now you tell the landlord that you want to buy it, and landlord also want to sell it. So you become the owner of the house. In such cases, you will, instead of paying rental, you will be paying lump sum amount to the landlord. So the conveyance deed you get signed in your place gets novated in place of the lease deed that you have. Is it okay?
Yes, sir. Okay.
Okay. Next is agency agreement. Agency means anybody who can perform an act can also perform it through another person, through an agent. Say, court has called you, issued you a summon or asked you to produce certain document. Normally in those summon, it is written that you either attend or through your attorney to attend the court. Like that, you want to sell motorcycles. You are a, say, Hero Motor Corp, and you want to sell motorcycle all over the country. It is very difficult for you to engage employees, make showrooms, and then run them, then control them on a day-to-day basis. What you can do is you can appoint agents who agree to do the sale for you on certain commission. That commission could be on the basis of the per piece sale that they make, or they could do it on the basis of certain percentage of the amount they may be getting. So the agent is a person who is employed to do any act for another person or to represent another person in dealing with the third party. So that is an agent. And in anybody who acts on behalf of another person is called principal, and the person who agree to do the act on behalf of the principal is called agent. Chapter 10, section 182 to 238 of the Indian Contract Act provides for the provisions relating to the agent. This chapter is very, very simple, friend, in the sense that it provides for how the agents are appointed, and once the agents are appointed, what are the rights and obligations of the agent, what are the rights and obligations of the principal. So agent, as I have told you, is a person employed to do an act for another or to represent that other person in dealing with a third party. So many times you want to sell something, say grains. I am a farmer. I want to sell my grain in the market. I bring the grain and put it with the artia or soul selling agent or mercantile agent, and that fellow does the sale on my behalf. So that person is called sale, and he gets certain commission out of the sale. The person for whom such sale is done is called principal. Test of the agency is, it will be seen. So there is lots of difference between an agent and a servant. What is the difference between agent and a servant? Normally, servant works under the overall supervision of the principal, but he is not authorized to represent the principal to the third party. But agent normally works independently, and he makes a commitment to the third party on behalf of the principal. So whether a person has a capacity to bind the principal and make him answerable to the third party. So if the answer is yes, he is an agent. Otherwise, he is not an agent. Whether he can establish a privity of contract. Say I am representing, say, institute. Whether I can make any commitment on behalf of the institute? No, I cannot make any. I can only deliver this lecture, but I cannot tell you that your fees will be waived or it will be increased or you can pay it later. I cannot make any commitment on behalf of the institute. So I am not an agent of the institute to that extent. I am an independent consultant given only a limited scope of work. So I am not an agent. But in case there could be a situation where I have been given the authority to make commitment on behalf of the institute, in that case, I can be an agent. So agency is a comprehensive word used to describe the relationship between the person agent and another person called principal. Now question arises, can an agent be a person competent to contract, or he need not be a person competent to contract? As far as principal is concerned, definitely he should be a person competent to contract, because on whose behalf the contracts are entered into. But as far as agent is concerned, agent is only a conduit or a pipe or just carrying mechanism. An agent, as far as third party is concerned, he need not be, he can even be a minor and need not be competent to contract. But as far as relationship between principal and agent is concerned, in case a principal decides to appoint a minor as an agent, as far as third parties is concerned, he will get committed. But say if the agent commits a fraud or if agent misconducts himself, principal will not be able to get any remedy out of such kind of an agent who is not competent to contract. Now, what are the powers and duties of the principal and agent? As per section 211, an agent shall act within the scope of his authority that his principal confers upon him. He shall also strictly follow the directions of the principal. As per section 213, an agent shall be under the duty not to disclose any confidential information about the principal. So these are the obligations of the agent. He will act within his authority given to him by the principal. He shall follow strictly the instructions given by the principal, and he shall maintain confidentiality in their relationship. What are the powers of the agent? He can have a power of getting remuneration. He can, and in case principal is unable to pay him remuneration, he can exercise lien on the goods. He has a right to be indemnified. In case he incurs any expenditure on behalf of the principal, he has a right to be paid that amount. So this is the principal-agent relationship. In case now you have any question on this subject, feel free to ask me.
Sir, how many questions are expected, sir?
Maybe 3 or 4 out of this, whatever we have studied till morning. Maybe another 3 or 4 out of the top topic that we will be studying now. Can I close the PPT and you can go on asking question. What I do is I close this PPT and open up another PPT.
Yes, sir.
Okay, please feel free. Till then, you can go on asking the question.
Yes, sir. I have a question. This
Yes.
is Mayur Shetty. Sir,
Yeah.
now what is happening is because of this digitalization, we are trading with a lot of people who are in different states and different places.
Yeah.
Now, all these agreements happen through portals like IndiaMart or Amazon. While Amazon
Yes.
is completely safe, now what
Yes.
happens from IndiaMart? I am ordering things from Himachal Pradesh, staying in
Yeah.
Karnataka.
Yes.
So
Yes.
in such cases also, we have some invoice where we have to make 100% payment before delivery. And
Yes.
after delivery, find out that whatever was promised on chats or something are not
Yes.
to the quality, or they
Yes.
defect on the promise of good quality. So in
Yes.
such cases, chats and all can form as a legal tool to file injunction or something.
Yeah, definitely that is taken as a communication, and there is also an application of the one of the provisions of the Sale of Goods Act, which says in case you are buying some item as per the description, which means description is given on the e-commerce operator's website,
Yes.
the item that you get should conform to the description. There is another principle of the Sale of Goods Act which says in case you are buying something based on description and based on the sample. Say you are getting something printed where the specification of the printing is described by the printer, and at the same time he gives a specimen of the paper on which he will be printing. In such cases, the bulk that you get should conform to the description as well as to the sample. So these are the principles which will apply to your contract. Even if you have, in case you have bought something, even at the time of buying, you will have certain terms and conditions. Goods are subject to your acceptance. In case you do not like the goods, you can return it within 3 days or 5 days. Or in case you find any defect, that there must be some customer care number given. So according to that, you can seek your remedy in those terms and conditions. And in case you find that the e-commerce operator has cheated you, you can also file a case with the consumer forum.
Okay, sir. This applies to, sorry, just 1 minute. This applies to software services also, right? Not only
100%. 100%.
Okay, sir.
In the case of software supply, the client will always give specification of what scope of work he gives you, and then you build up a software, and it will be seen whether it meets the specification of the client. And in case it doesn't meet the specification of the client, then the client can always sue you for recovery of the money.
Okay, sir. Thank you.
Sir, one more submission.
Yeah, please.
Sir, this contract has been enforced since 1872. That means during the British period only.
Yeah.
After our independence, why this act has not been established as per some 1947, 1950? Why we are telling still?
Because this contract act contains such broad principles of, you must have seen that we have all liberty to enter into our own kinds of contract. So the legislature, the trade and industry did not feel the necessity of changing it, because those universal principles of trade, they are still as much applicable today as they were. Just say, for example, my friend is saying that now e-commerce things have come. Even on the e-commerce, they are based on the basic principles of the Indian Contract Act and the Sale of Goods Act. Can I proceed further?
Sir, I have one small question. You
Yes.
said the law of limitation, which
Yes.
is up to years. It is considered from which date? It is from the end of the contract or from the beginning of the contract?
When the cause of action arose. Law of limitation is when the cause of action arose. Say, for example, you have a right to receive, say, promotion.
Okay.
And the department doesn't give you. When did they finally refuse you that they will not consider? Because if you are not being promoted, there must be some reason, and you might be knowing that there is some reason in your favor. You make an application and representation. The day they reject it, from that date, the cause of action will arise. Like that, there are certain principles relating to the law of limitation. In case there is a running account between you and some of your vendor, so it will be seen when the last transaction took place. From that time, and you want to make a final settlement of the account, law of limitation will start from the day when the last transaction takes place. Then 6 or 8 years, according to the schedule attached with the law of limitation, so that time will be calculated.
All right, sir. Thank you.
Can we proceed further now, friends? As a part of your course, you have a sale of goods act. There are general provisions relating to the sale of goods act, and there are separate section relating to the auction. Let me first of all take up with you what is the Sale of Goods Act. Sale of Goods Act comprise of certain rules and regulations relating to how we sell goods. And there is a definition of the goods under section 2(7), which means all movable commodities, including shares, securities, etc. It also includes certain growing crop, timber, etc. So there is a goods. And sale is whenever the ownership of such goods is transferred from one person to another, so for a consideration called money, then it is called sale. So there are a lot of principles relating to the Sale of Goods Act, but surprisingly, they have asked me for this today's class, I only have to take up certain specific provisions, section 67, relating to the auction. And today what I do is, I skip the portion relating to sale of goods today. Maybe 3 days later, I have to take up this same Sale of Goods Act with you. So these earlier provisions I will take up a little later. But before that, I take up with you the provisions specifically relating to auction. What is an auction? See, I told you what is sale. Sale is transfer of ownership of goods from one person to another for a price. Price means money or money equivalent, right? And auction is also one of the kinds of sale. And what is the kind of sale where you want to, if I am a seller, I want to maximize the price that I get. And what I do is, instead of approaching one person and telling him, sir, please buy my thing, I make an offer to you to buy my thing, I approach another person. So in case I have a fairly large quantity of goods, what I do is, I issue a notice for auction. I issue an advertisement, notice, or some kind of a circular in the neighborhood that say, I'm going to US, I want to sell my old furniture and quickly I want to sell it. What I do is, I put a poster at the crossing, and I also issue a small newspaper advertisement. I also send a lot of WhatsApp messages and tell people that I am ready to sell my furniture on auction. So the term auction is something different than the usual buyer and seller term. Usual buyer and seller term is when I approach a particular prospective buyer to buy this furniture for me. And auction is when I invite anybody and everybody to come and bid for the price which that person is willing to pay. So whenever I issue this advertisement, this is invitation to make an offer, telling people you come and offer what price you want to give me for purchase of my, say, old furniture. And lots of the prospective buyer come, they inspect the furniture, and then they bid the price. Somebody is willing to pay me 20,000, then I hold on. Other person offer 22,000. I still hold on. Another person offer 23,000. The process goes on till such time that the seller decides that they see that nobody else is offering the better price. And I also feel that price which is offered in this particular auction is acceptable to me. The subject auction is one of the kind of a sale where goods or property is sold or proposed to be sold to the highest bidder. And the purpose is to fetch the highest price. I hope you must have either conducted the auction many times or might have at some point of time might have participated in the auction. So when you go and bid for the price. Okay, auction is a proceeding at which the people are invited to compete and make a competitive offers for purchase of the property or goods which are put up on sale by the seller through the successive offer of advancing sum. Successive offer of advancing sum means somebody offers 20,000, another offer 21, then 23. I keep on waiting, and then I also keep them giving the signal 21,001, 22,002 until it the price reaches a point which is acceptable to me, and at that time I say 22,003, which means that I either beat the drum or I throw the hammer or I can make some kind of an announcement, as a result of which the persons who are assembled there, they get to know that those goods have finally been sold. But once the hammer is struck or drum is beaten or 1, 2, 3, or once the 3 is sounded, these are the various ways of communicating to the audience that the sale is now completed. So once the announcement is made about the sale, say 1, 2, 3, when the very moment I say that now I will not accept any progressive bids, so contract is already done in favor of the highest bidder. So what are the steps involved in auction? I have already told you that we have to issue an advertisement. There has to be advertisement or proclamation of the auction of the sale to make the public know that such an auction is taking place. Advertisement gives the description of the goods, date, time, venue of the auction, and also the name of the auctioneer and such other conditions as may be prescribed, as may be necessary in order for the prospective buyers to know as to what item is being sold, and certain description of the goods can also be given. See, friends, issuing of a advertisement or a proclamation becomes a little expensive because newspaper charges heavy amount. What we can do is we can also issue a small advertisement or a proclamation, but at the same time bring out a detailed catalog containing terms and conditions of the auction. So in such cases, that detailed in the advertisement we can see this auction which is subject to terms and conditions which is available at a particular website, or you can also give for a detailed terms and conditions, please contact at this mail, then you can send them the detailed terms and conditions. While the newspaper gives only catch line of inviting prospective buyer, detailed terms and conditions could also give the description of the goods, whether it's old or new, or whether it is on as is where is basis, or you bear any responsibility, when the prospective bidder has to make payment of the price, whether credit is allowed or not, during what time the prospective buyers can inspect the goods. So those kind of a details you can contain in the, if you put them all into the newspaper advertisement, it will become a, say, 6-page it may become a 4-page or 6-page document. So it will become very expensive. But in the newspaper, if you say that detailed terms and conditions are available there, so you can contain these detailed terms and conditions into the catalog. Then friends, apart from the advertisement and this catalog or a description list or terms and conditions statement, you can also make certain statement at the rostrum. Rostrum is kind of a, what should I call? Rostrum is kind of a raised platform from where the statements are once again said. You can contain certain terms and conditions. Friends, bid will be like this, so you are free to make your bid, or any bidder has to deposit at least 10,000 rupees, because there is also a danger that bidder may back out of the, he may bid for a price, say 25,000, but later on he realizes that 25,000 is too much, he might want to back out. So in order to contain that or avoid that, you may also call upon the prospective bidder to make certain deposit of the earnest money or the earnest money or security deposit, and make a condition, anybody who bids and do not own the bids, then he will be liable to forfeiture of this amount. These kind of terms also you can make. As soon as hammer is struck down, which is typical notification by the seller that the offer of the buyer has been accepted, the bargain is considered as concluded. There is one more thing, friends, that simple principle of offer and acceptance apply over here also. Whenever a bidder quotes a price or raises the bid, it is deemed that he has offered to buy that product at that price. Till the hammer is thrown, or till the drum is beaten, or till the such offer is accepted by the auctioneer, till such time he has a right to withdraw from the auction. But once the drum is beaten, or 3 is said, or once the announcement is made, then the property becomes his and the contract has come into existence, and then he has no right to withdraw from the contract. Seller has no right afterward to accept a higher bid. So once the drum is beaten, that means the property becomes that of the person who has made the bid, and the seller loses the right to accept further increase in price. In the process of the bidding auction, the seller also has a right to reserve the price, the below which he will not sell. But is it necessary that reserve price should be told to the prospective buyer? No. But but one thing has to be disclosed, that in the terms and conditions or in the advertisement, it has to be said that the seller has a right not to make any sale if the price received doesn't match its reserve price. So this kind of a condition is written, and if this condition is written in such cases, so because once you are announcing a auction, lots of people will be coming to with the hope of buying, and in case at that time you decide not to sell it, so they will be put to some kind of an inconvenience. But if you have already said that this auction is subject to reserve price and it will not be sold in case reserve price is not received, in such cases there is a proper notice to the prospective buyer. So the property in auction cannot be sold on credit basis. So one can contain a terms and conditions that anybody in whose favor the bid is decided, they will have to deposit the remaining amount within this period. You might also be seeing many times these auctions of the immovable property or some of the expensive equipment are done by the government department. In such cases, they say anybody who wins the bid will have to deposit money within, say, 5 days. They will have to remove the goods within 7 days. Those kind of a conditions can also be put in the catalog. How is auction conducted? Advertisement specifies how the auction will be conducted. It will also specify if there is any mode other than ordinary one. So in case there is, these days a lot of popularity about e-auctioning also takes place, where bids are invited electronically, terms and conditions are announced electronically, security deposit is accepted electronically, and when one person makes an offer, like a display board of a stock exchange, like that display board of a computer go on intimating that what is the maximum price available at that particular date. In such cases, e-auctioning may also remain open for a couple of hours or maybe 1 or 2 days also. Sometimes that can be kept open till it is finally decided. So in such cases, it is important that in the case of an auction, in case there is a misdescription about the goods, or if either party by guilt, fraud, or deceitful representation whereby bidders are misled, so in case certain descriptions are given or goods are not conforming to that description, in such cases, the prospective buyer can rescind the contract. That means they may sue the seller for any misrepresentation that they have made. Like that, the sale is thereby rendered voidable. That means in case somebody makes a misrepresentation in the advertisement or in the catalog, in such cases, the prospective buyer can avoid the contract and sue the seller for the compensation. So in the Sale of Goods Act, for friends, certain provisions are given. Section 64, as I said in the beginning, contains certain rules relating to sale by auction. In case the auction is done in lot, a single material might be required to be sold, but in order to get the optimum price, the prospective seller or the auctioneer puts different lots of say 20 pieces each or 200 pieces each. Each lot is considered to be a separate contract and will be subject to the separate contract of sale. Like that, when the contract of sale is complete in auction, every bidding is nothing more than an offer, I have already told you, and till then bidder may withdraw. But once the drum has been beaten or 1, 2, 3 sound has been announced, and once the auctioneer makes an announcement that sale is complete, thereafter bidder cannot withdraw and contract gets completed. So contracts gets completed either by the fall of the hammer or by any other usual method about which announcement has been made either in the catalog or at the statement made at the rostrum. Can seller himself bid during the auction? There is a seller, in order to get a maximum price, he also clandestinely appoints some of his agents to start bidding in competition with the prospective buyers. A seller can bid provided he has made an announcement to that effect either in the advertisement or in the description or the catalog which he has brought out. In case he has not made any announcement and still he clandestinely he appoints some of his agent to start bidding in competition with the prospective buyer, so such a bidding will be void. In such cases, the prospective buyer can avoid the contract. But if he has already made an announcement that he has also has appointed agent to bid in competition with the prospective buyer, in such cases he can appoint only one bidder and not more. And in case there is no such announcement, then the auctioneer, which is an agent of the seller, he should not allow any bidding by the seller or his agents themselves. In case of a sale by government auction, the sale is not complete till the bid is accepted in the form of a confirmation by the collector. So there is a specific protection has been given in respect of the government sale. In government property, whenever it is sold, and when maximum price is received, then everybody is asked to hold on. People go and take the permission of the approval of the collector, because these bidders are very junior people and they are the agent. They do not have much stake in the property. In order to safeguard the interest of the government, prior permission of the collector is provided for. It is immaterial whether there is any condition like goods not removed till payment, or those kind of conditions can be put. That normally there is no condition to sell those goods on credit basis, but this kind of a condition can be there, that in case money is not deposited, goods will not be allowed to be carried, and the time limit can also be imposed. By this you deposit the money, by this you remove the goods, and in case you do not remove the goods, you have to pay another liquidated or damage charges. So that kind of condition can be. I've already spoken about the reserve price can be declared in the bid. Whether a seller can bid in the auction, we have already spoken about this. Only he can bid if he has made a disclosure to that effect. So in the last topic in this is obligation of the auctioneer. Obligation, if there is a reserve price declared, auctioneer cannot sell the subject goods below the reserve price. And in case he is unable to get the reserve price during the auction, then he cannot, and somebody in the private sale offers a higher price, auctioneer cannot make a private sale to anybody except with the permission of the seller. And the property in the auction cannot be sold on a credit. So there is no presumption about selling the property in the credit. Then auctioneer also does not have any authority to allow any adjustment of recoverable by the prospective buyer. So prospective buyer, the seller might be owing certain amount to the prospective buyer, but in this case of an auction, the prospective buyer cannot withhold or cannot adjust the money which he has to recover from the seller. Then the auctioneer cannot make it by a private sale, and even if this were to fetch the more price, it is not possible. Auctioneer has no authority to rescind the contract on behalf of the seller. He cannot warrant the goods sold. He cannot warrant means he cannot call back or he cannot guarantee the performance of the goods. To deliver the goods sold without payment, he has no authority. Auctioneer has no authority to deliver the goods without recovery collection of the price, or to allow the buyer to set off the dues from him. So in case the buyer has some recoverable from the seller, auctioneer cannot allow adjustment of those price. So this is it about the auction. In case you have any question about the auction, please feel free to ask me.
Sir, in case of government auction, you were telling that it should be taken permission from the collector. That point I could not understand.
You could not understand.
Yeah.
See, these auction people are normally junior people. They are normally agent, आड़ती जिसको बोलते हैं ना, या दलाल या agent वो होते हैं. And whenever government property is sold, the terms and conditions of the sale by the government department could say that the final decision auction will be subject to approval by the collector, because collector has to do lots of auctioning of the property in order to. Can I, in the meantime, also change my slides?
Yes.
Change my PPT?
Yes.
Okay. And in such cases, even though the drum might be beaten, or even though the hammer might have fallen, but the sale will take place. The final contract will come into being after it has been approved by the collector. So this kind of a terms can be included. But in the case of a private sale, such condition is normally not included.
Thank you.
Because it is written in the Sale of Goods Act itself.
Yes.
Okay.
Okay, thank you.
Can you see my next PPT?
Yes.
You can see it and you can hear me also?
Yes.
Quickly we can start. Law of tort. What is tort? Normally you will find, friends, that remedies, punishments for all offenses or wrongdoings are given either in the Indian Penal Code, but if it is a civil contract, it is given in the contract that we entered into, or it is given under the Indian Contract Act that we have studied so far. Though over a period of time, efforts has been made that all those offenses for which punishment has to be levied are provided for in the Indian Penal Code, under the criminal laws, under the Companies Act, for example, under the Income Tax Act, under the GST law. So in case you commit this, you are liable to pay penalty of this much. In case you do this, you will be liable to imprisonment for this much period. In case you do this, then both those kind of things are there. Like that, in the case of civil law, normally rights and obligations of the parties are decided by the parties themselves at the time of entering into the agreement. Is it right? But let us imagine a situation which does not provide for a specific law for administration of justice. What would happen in that situation? Say, for example, I have a small tank posted at the rooftop, and suddenly water overflows and it damages some neighbor. Would you find that for such a remote kind of an activity, some offense or some will be written in the Indian Penal Code? May or may not be. There might be some general punishments given that because of my negligence, if some loss is caused to the neighbor, then I might be liable to pay compensation. Or maybe there might still be some situation where in a kind of a human endeavor, specific penalty for specific activities not provided either in the Indian Penal Code or under any law. Then what will happen? What the court will do? The court in such situations administer justice. In what way do they administer justice? They keep in mind principles of justice, equity, and good conscience. The principle of justice, equity, and good conscience is the court under such circumstances where no specific provision of law is there, they will try to act fairly, equally to parties which go before them. So tort means a breach of some duty which is independent of a contract giving rise to such civil action. Which means in case you and I enter into contract, our rights and obligations are decided as per the contract. But imagine if I am a civil engineer working for a municipal corporation, and while working for a municipal corporation, I have been assigned the job of digging the road and doing some repair work to the sewage. In such cases, what is my duty? My duty is to perform to the best of my ability. And in case I leave those dugout place open as a result of which, and do not put safety marks or red portion or some light, or if I do not put a circle or some prohibition around that dump which I have created, and as a result of which some loss has been caused to some pedestrian or some child falls into it, some motor vehicle falls into it, then what will happen? Because of my negligence in doing that work, damage has been caused to some road user. In such cases, what will happen? I have been a servant of the municipality. In such cases, municipality is liable to compensate me of the loss which has taken place to me because of the negligence on the part of the municipality's engineer. So that's what is called the negligence done by the municipal engineer in leaving the dump open, exposing outsiders to the risk of that loss, is called tortuous act. And the person who commits a tort, and so tort consists of some act or omission done by the defendant. What is defendant? Person who commits negligence and somebody is hurt. Anybody who is hurt, he is called plaintiff. Anybody who initiates a case in the court of law is called either an applicant or a applicant or a plaintiff. And anybody against whom the case is initiated is called defendant or respondent. So in this case, the municipality, since I have been hurt because of the negligent act by the municipality or by its officer, so I file a case in the court of law. I am a plaintiff and municipality is the defendant. So tort consists of some act or omission done by the defendant. Defendant is also called tortfeasor, then a person who has committed a negligence or a tort, whereby he has without just and reasonable cause or excuse caused some harm to the plaintiff. So I am a plaintiff, I am a road user, and loss has been caused to me or damage, or I have been hurt because of the negligent act of the municipality. So I can file a case in the court of law against the municipality. Municipality is a defendant or a tortfeasor in this case. To constitute a tort, there must be a wrongful act or a omission of the defendant. Otherwise, they will not be liable. And the wrongful act must be such as result in causing legal damage to another person and must be such a nature as to give rise to a legal remedy. So there is two things here one should keep in mind, that is legal remedy and loss, damage or a legal remedy. There is a principle which says ubi jus ibi remedium. Where there is a right, there is a remedy. Wherever I have a right to use the road, and in case there is any damage caused to me in the use of a road, I have got a remedy. There is a very interesting case, friend. Ubi jus ibi remedium is a Latin phrase which says wherever there is a right, there is a remedy. And in case there is a right and no remedy, what is the point of having that right? So one has to have a remedy. There is a very interesting case. I will try to explain it to you, that there was a voter who went to vote at the polling station. He had he's a fundamental right to vote, so he went to the police station. The official there negligently told him that his vote is not there, and he was sent back. Later on, it was realized that the party he wanted to vote for has already won with a substantial majority. So as a result of it, he did not incur any financial loss. That means the candidate he wanted to vote for has already won by a substantial majority. But does he have right to sue the electoral officer or election commission because he was unreasonably, illegally deprived from voting? Yes, that's what this principle says. Ubi jus ibi remedium. Where there is a right, there is a remedy. So that election department was liable to compensate him. In this connection, there are two more principles, friends. Injuria sine damnum. Injury without damage. So the example that I have given you, even though in respect of the voter, no financial loss has taken place to him, but still he has a legal right to sue the election department because he was deprived from voting. But there could be something reverse to this also, and reverse to this could be principle of injuria sine damnum, where there is an injury without loss. There is an injury without loss. That means an absolute right is one, the violation of which is actionable per se, that is without proof of damage. So that's what the principle I have told you. There could also be injury sine damnum. Sorry. There is another principle, that is damnum sine injuria, which means there could be loss, say a financial loss or a damage, but for which you do not have any remedy. Can you think of any example of that? Damnum sine injuria. That means there is a loss incurred to a particular person, but for which he has no injury, means he has no legal right to take resort to that loss. Take for example, I am a provision store. I am selling day-to-day things, and now there is also an upcoming of the e-commerce operator. Particularly during these lockdown days, while my sale has gone down quite substantially, the sale of the e-commerce operator has increased manifold. In such cases, can I sue the e-commerce operator against the loss which is taking place to me because I am losing the sale? There is a very interesting example of this, that is Gloucester Grammar School. There was a gentleman who was running this school, and in the neighborhood, somebody else came and he opened a similar school in competition with this particular school. And this person went over to the court of law saying, because of the opening of a new school, my number of students have gone down, as a result of which I have my that sale has come down, my profit has gone down, so I am incurring financial loss. Could he sue his competitor? As I gave an example, if I am a provision store, small provision store, or a street corner shop, and my sale has gone down because of the coming into being of the e-commerce operator, can I sue those e-commerce operators? No, because just as I have a right to do business in the things that I sell, like that e-commerce operator and other people also have a right to do their business. So irrespective, despite the fact that I incur financial loss because of the competition by those people, but still I have no right to sue them. Okay, now I take up with you certain specific kinds of torts. And these torts are as old or even older than the Indian Contract Act and older than the Indian Penal Code, because even at the time, even when there was no such law, the court always functioned on the ground of, on the principle of justice, equity, and good conscience. So it's as old as the judicial system itself. And with the passage of time, lots of these torts, lot of these torts which are part of the law of torts, about which no specific penal provisions were there. So they were covered under law at that time, but now with the passage of time, some of these provisions have been covered under the Indian Penal Code or under some provision of the company law or under Income Tax Act, or where they have been incorporated. Say for example, assault. What is assault? Assault is a sudden or a violent attack, an attempt or offer to do a violence on another person. Sometimes somebody is say creating discomfort for you, and you want to, just as against a dog, we raise our hand as if to hit them. So this process of raising hand as if you are trying to hit him is assault. As holding a stone or a club in a threatening manner, it's an assault. So assault is a tort, but it's also a offense under the Indian Penal Code. So assault includes a threat or an attempt to inflict offensive, a physical contact or a bodily harm on a person as if by lifting a fist in a threatening manner. जैसे कि उसको मुक्का दिखाते हैं, so we as if we are hitting that person, so that is an assault. So nobody has a right to threaten another person or scare another person by way of a assault, and that puts another person in a immediate danger that some loss will be or damage will be caused to him. Just when we raise our hand in order as if in a fist that I will hit you, even if it is not hit, so it is an assault, and anybody who commits a assault is liable to penalty. I think some imprisonment is there under the Indian Penal Code. Like that, battery is a little ahead, goes little ahead of the assault. An intentional or unpermitted act causing harmful or an offensive contact to a person of another is called a battery. If I raise my hand, do not touch the other person's body, it is an assault. I raise my hand and hit or even touch or unpermitted touch to another person, then it is a battery. Battery is concerned with the right to have one's body left alone. Nobody has a right to touch me or hit me, or I have the right to safety. So battery and assault are both tort as well as crime. Usually battery is prosecuted as a crime only in cases involving serious harm to the victim, and that also depends upon individual to individual. Say somebody, I am going on a bus, somebody maybe touches me and give an unfair touch to me, so maybe court will give some nominal relief. But if somebody touches, say some very prominent person, say some film star, or you are touching him without his or her consent, in such cases the court may be tempted to give impose higher penalty or imprisonment upon the person who commits a battery. Assault under the Indian Penal Code, it is written that whosoever assaults or uses criminal force to a person otherwise than on grave or sudden provocation given by that person shall be punishable with imprisonment of either description for a term which may extend to 3 months. That means if you commit assault, imprisonment may be put for a period of 3 months. Like that, in case of a battery also, some imprisonment must be given. Next is false imprisonment. If somebody detains you or your property without any lawful reason, in such cases that the person who falsely or put you to a false imprisonment is again liable to tort, and the court will impose fine or a imprisonment upon that person. So even in case of a government agency, in case they imprison you, in case they detain you, our fundamental right requires they have to present you before the competent magistrate within a period of 24 hours. Like that, there is another kind of a tort, that is trespassing and invasion on privacy, that somebody intrudes on your private property or property of another without permission. In such cases, even if no financial loss has taken place to you, still you have a right to sue him for trespassing on your privacy. Like that, somebody unauthorizedly reads your emails or your laptops or your letters, even if so, by virtue of reading your email, he may get some business secret. In such cases, you can definitely sue them. But even if no loss has taken place to you or damage has taken place to you, still you can sue them for trespassing or invasion into your privacy. Like that, in case of defamation, defamation is another kind of a tort, act of damaging the good reputation of someone. And this damaging of a good reputation of someone may be by way of a just expression, gesture, spoken words, that is called slander, or it could be by way of some written paper, that is somebody might have written a article or a letter or a letter in the newspaper, that is called a libel. Whenever defamation is done through the written document, it is called libel. And whenever it is done by just word of mouth or through the gesture, it is slender. Whether it is a slender or a libel, so a person can claim compensation for defamation which might be caused by another person. Defamation is which makes you lose the respect or in the circle of the known people. So that's called a defamation. There are, so friends, once anybody commits a tort, then what are the remedy available against whom the tort is committed? The remedies are of two kinds, that is judicial remedies and extrajudicial remedies. Judicial remedies are those remedies which are afforded by the court of law, while extrajudicial remedies are those which are available to a party in certain cases of tort by his own act alone. So let us see what are the judicial remedies available. So whenever a tort has been committed against you, say somebody has trespassed on your property, somebody has committed defamation against you, somebody has done a assault or a battery, you can make an application to the court of law and ask for awarding of the damages. Like that, the court can also grant injunction, that is granting a judicial order restraining a person from beginning or continuing the action threatened or invading the legal. Say somebody has trespassed on your property, the court may issue a legal order to that person to vacate your property. In such cases, it's a granting of an injunction. Then specific restitution of the property. Somebody has taken away your property or he has deprived you of your property. In such cases, court may direct that person to restore that property to you. So that's also a judicial remedy. Then expulsion. Then next is, what are the extrajudicial remedies? So without approaching the court of law, you also have got certain powers in your own hands. If somebody trespasses on your property, you can expel that trespassers on the property. In fact, in the right of the self-defense, even if you cause the death of the trespasser, then still it will not be an offense against you. But condition is that whenever you are wanting to expel the trespasser, the force which is used to expel the trespasser should not be disproportionately more than the force which is required. There is a very interesting case, friends. At night, some thieves entered somebody's house and they were burgling the house. The person who was sleeping, he was keeping a pistol with him. He woke up. As soon as he woke up, the thieves started running away. And as the thieves were running away, and on the back, he fired them and killed two of them. As a result of which, it was seen whether this person has fired in the exercise of the right of the self-defense in order to scare the trespassers. The court held that in this case, he has used a force which was disproportionately more than what was required, so the person was held guilty. But in case the same thieves were in fighting with a particular owner, and in that case, in that process, even if the trespassers were killed, then the use of the force would have been considered as reasonable. Like that, as self-defense, as I said, is the best form of a defense. In such cases, if somebody enters upon your land, you have a right to re-enter upon the land to the extent you can at the spur of the moment. So the God has given us the right of self-defense. Like that, recapture of the property, the action of taking back without legal process the property of one's own which has been wrongfully taken away. You can also take back that property in case if some thief is running away with your bag or a purse, you have a right to run after him and capture him and also snatch or recapture the goods from him. Like that, distress damage feasant. This distress damage feasant is a common law self-help legal remedy whereby a person who is in possession of the land may impound the chattel. Impounding a chattel means you have a field where somebody's cattle or somebody's animal has come and he has destroyed your field or maybe spoiled your crop. You have a right, say somebody's cow has entered upon your field and done damage to your crop. In such cases, you can withhold that particular animal till your compensation is paid by the owner of that cattle or of that animal. Like that, friends, you can also take any action relating to abatement of the nuisance. If some damage has been caused to you, you can take steps for reduction of that nuisance. So these are the 5 steps which you can yourself take up, and these are the 3 steps which you can take up with the help of the competent court. But before I tell you about the extrajudicial remedy, there is a caution, and the caution is extrajudicial remedies which are in the nature of self-help should not be normally resorted to, for the person resorting to them may frequently exceed these rights. Sometimes he may exceed the force that he is using and may be faced with the case of civil or criminal allegation that he took the law into one's own hand. So while we have a right, friends, while we have a right to self-defense, we have a right to protect our body and our property, but the exercise of the right should not be taken beyond a point. So one should see, make a delicate balance between right to exercise of the right to self-defense and not taking the law onto our own hand. So what are the measures or damages in case of evaluation? In case of evaluation, you will have to estimate the amount of compensation which could, in the event of the commission of a tort, will be payable or would be receivable in the case that you are valuing. So measures of the damage is an important aspect as far as the valuation and valuer is concerned. The expression measure of damages means the scale or the rule by reference to which the amount of damage to be recovered is to be measured. Damages may give rise to an amount, they may dwindle down to a mere nominal. So as I said, in the case of a assault or a battery, sometimes the court may give a very nominal damages, but sometimes the court may also award what may be called as exemplary damages. So all this is left upon the court. So damages may give rise to an amount or may, okay. The law does not lay down as to what shall be the measure of the damages in action for tort. The measure is vague and uncertain and depends upon variety of causes, facts, circumstances, depending upon the status of the person who is aggrieved by the tort committee. Say, for example, somebody writes an article against me. So in my case, they may award a very small or a nominal compensation. But if somebody writes a similar false articles against some very important person, say some film star or some say political leader, in such cases, damages claimed and awarded by the court may be very heavy. Likewise, in case of a battery, false imprisonment, slander, etc., the status of a person, degree of violation, trade and profession of the party injured, as well as the person who committed the tort or injury will also be taken into account. The common law says that damages due to either breach of a contract or a tort or the damages of such an extent in order to compensate the person and which give the injured party the reparation of the wrongful act. So in case there is not much of a loss which has taken place to the aggrieved party, then not much damages may be awarded. So if there be a special damages which is attributable to wrongful act, that special damages may be, or say for example, some negligence by the doctor in case it is committed. In such cases, court may be tempted to award exemplary damages, not reasonable small damages. Exemplary damages are a common law damages are purely compensatory except where plaintiff has injured by the operation. Say for example, if some police fellow or some tahsildar or some government authority or some tax authority harasses you beyond a point, in such cases the court may be tempted to award exemplary damages against that person. Damages in case of a personal injury may be caused non-pecuniary as well as pecuniary loss by the plaintiff. Say I have been caused some personal injury, I have been hurt, so I may have to incur some money upon my treatment. So they are the pecuniary compensation, and there could be non-pecuniary loss that I might have suffered, inconvenience caused to me, mental harassment caused to me. So for both the government that the court take into account. Pain and suffering, loss of amenities, loss of expectation of life, all these are taken into account for the purpose of calculation of the compensation. So friends, any question you have? Any issue you have, friends? Anybody listening?
Yes, sir.
All of you are listening, or what has happened?
Yeah, we're listening.
No, everybody listening.
Okay, you found it interesting?
Hello.
Yeah.
I have a question.
Any question you have?
Yeah, I have a question.
Please.
What kind of legal issues the valuer will face during his discharging of
Legal
duty?
issue valuer will take, first of all, while valuing, you will take a management representation as to whether any proceeding, court proceeding or claims of the third party involving violation of the Indian Contract Act or any criminal law or under tort is ongoing against the company. And once they give a certificate, and they may not give a blank certificate, they may say that following cases are pending against the company. Then in that cases, you will try to value what are the possible amount of damages which can be imposed. You may also take a management opinion on that. And whenever you give a valuation, then you may say that this valuation is subject to such and such following cases pending against the court. And while you give that detail, you can also say, estimate that likely amount of the damages which might or might not be imposed by the court. That's what the importance is.
Okay.
While you are asking question, till then, can I change my PPT? I have one more small topic with you, but that topic is you are already quite familiar with it. But still, I want to, since it's a part of the course, I want to take up with you.
Yes, sir.
Can I?
Sir, one submission.
Yes.
Out of the 4 topics, how many questions will be covered?
Maybe 8 or 9, maybe 10 maximum.
Is it to only theoretical or any data?
In the examination, you might be aware that they ask for multiple choice questions. So in the multiple choice question, it is very difficult to predict that how many they may give. But normally, this syllabus comprises of you out of all the 4 topics, you may get maybe 7 to 8 marks maximum. Because the main topic for your examination is valuation. In that case, as far as the preparation for the examination is concerned, you have to study valuation rules under the Companies Act, and then you also have to study the valuation standard, international valuation standards. So they, as far as marks are concerned, you probability of getting more questions are there out of in the valuation standard. But all the more for the day-to-day functioning as a valuer, you will need that knowledge of these subjects. Can you see my new PPT now?
No, sir, no.
You are not able to see it.
Yes, sir.
We can see. We can see.
Sir, we can see it. We can see it.
We can see, sir.
What subject you can see?
Arbitration and Conciliation Act.
Arbitration and Conciliation Act.
Exactly. One of the important aspects of doing business in any country is to deal with the dispute resolution mechanism. So you have studied long provisions of the Indian Contract Act that where dispute can arise between the parties. And I think I think somebody has to close your mute yourself. Could you please mute yourself?
Yes.
Because unless there is a lot of disturbance is coming, so I am not able to focus. Yes, friends, I was telling you, one of the important aspect of doing business is to be able to seek remedies wherever there are violations, wherever there are breaches by the other parties. Then, and one of the most difficult thing in India is that getting the resolution of the dispute is very, very difficult. Though theoretically it is easy that you can file a case in the court of law and the court will order this remedy and then you are entitled to that remedy. But what it really happens is seeking remedy through the judicial process is very time. First of all, let me also take up with you, there are two kinds of remedies that one can take. In case there is a breach of contract by any party, any of your dealer or any of your factory or any of your employee, so you have traditional mechanism and you have alternate dispute resolution mechanism. Traditional mechanism means you have a hierarchy of courts in India. At the top, we have a Supreme Court of India. Below that, we have each state or union territory or some of the more than one state have a high court. Below the high court, we have a district courts where district judge, sub judge, and those people, they all are busy. They are all have been appointed in order to deliver you the justice, deliver you the remedy for whatever breach has been committed by those parties. But this system, friends, traditional system of courts, kacharis and all, this is number one, very expensive. Despite being, that means in order to seek a remedy through these, you have to engage a qualified advocate or a lawyer. Those advocates or the lawyer charge heavy amount of fees. Apart from that, the seeking remedy through the traditional justice delivery system is very, very time consuming. You file a case, you have a uncomfortable tenant staying in your premises, you file a case for eviction of that tenant and it takes months and years in order to get a proper eviction. So in order to avoid that, there is a alternate dispute resolution mechanism. And this alternate dispute resolution mechanism has certain degree of flexibility, which means, first of all, let me take up with you what is that alternate dispute resolution mechanism. Alternate dispute resolution mechanism comprise of arbitration and conciliation. It comprises of Lok Adalat, which are constituted under Lok Adalat Act, Legal Services Authorities Act of 1987. Then there is also a judicial settlement. Sometime whenever you file a case in a particular court of law, the judge normally after the complaint has been filed and the cross objection by the respondent has been given, before sitting to decide that case, the court calls both the parties and tell them whether you would like to go for a mediation. And if both the parties agree, the judge normally refers the case for mediation. And once the judge refers the case for mediation, then the application of the legal services authorities apply, because instead of fighting the case purely on law or on the basis of arguments and counter arguments spread over a number of months, these particular mechanism becomes easy, cheaper, flexible, and less time consuming. So, but today I'm not going to take up with you Lok Adalats and judicial settlement, but I will take up with you arbitration and settlement, which is a part of the Arbitration and Conciliation Act of 1996 as amended in 2015 and as amended in 2019. So under this, we will take up introduction to arbitration and conciliation, law of ADR, I have already taken up with you, types of arbitration, how arbitrator is appointed, procedure for appointment, whether court can interfere into the functioning of the arbitration, award, time limit, enforceability. conciliation and compromise. So these are the kind of things I will take up with you. I should also take up with you arbitration agencies like International Center for Alternate Dispute Resolution, then Indian Council of Arbitration, Chamber of Commerce and Industry, professional arbitration, their role in the bringing about the resolution to the disputes. So what is arbitration? So friends, it's already, our time is over, but can I have your permission to take another 15-20 minutes?
Yes, sir.
So in that case, you will have to shorten your lunch time, because the next speaker, I think, should already be ready by the next scheduled time. So I will try to finish the whole thing in about 15 minutes. So I seek your permission to carry on for another 15-20 minutes. Is it okay?
Yes, sir. Yes, sir.
Fine,
Okay.
sir. Fine.
The term arbitrator is not defined in the Arbitration and Conciliation Act, but arbitrator is a person who is appointed to determine means decide the difference or the dispute between two or more parties by their mutual consent. Why their mutual consent? Because the appointment of the arbitrator is not done by the government. It is done by the parties themselves. And how do the parties appoint an arbitrator? At the time of entering into agreement itself, the parties can foresee that in case there is a dispute or the difference, they can provide an paragraph in the agreement itself that the dispute will be referred to, say, a sole arbitrator or arbitrator, to the board of arbitral tribunal, in which one arbitrator will be deputed by each of the contending parties, and those two arbitrators shall appoint another arbitrator who will be called the chairman of the arbitration or the president of the arbitral panel. So in such cases also appointment can be done. Or this is when the appointment is done in anticipation of the dispute. But sometimes such an agreement does not provide for arbitration clause. In such cases, when the dispute or the difference has arisen, at that time also the parties are free to decide that, okay, instead of going to the court, we will seek a resolution through the arbitral process. So that at that time also they can do. So it is not enough that the parties appoint an arbitrator. The person who is so appointed should also give his consent. Okay, anybody who wants to appoint an arbitrator, that person should also give his consent. So arbitration means a reference of a dispute between not less than two parties for determination after hearing both the sides in a judicial manner by a person or persons other than the court of competent jurisdiction. So normally when you have a dispute, you file a case with the district court or a high court, depending upon the stake involved in that dispute. And once the dispute is decided by the court, you can also go for the appellate court. So this thing is also possible. So this justice delivery system is already provided by the government. But instead of going into this system, if you go to the person of your own choice, so that person could be arbitrator, so he can decide the case for you. Okay, what is the object of the arbitration? The object of the arbitration is settlement of the dispute in an expeditious manner, expeditious, convenient, inexpensive, and private manner to prevent it from becoming a subject for future litigation. So it's very easy, flexible, less time consuming. It also maintains certain degree of confidentiality. If you see some dispute between the multinational which are taking place at the High Court or a Supreme Court, you find that they are widely reported in the newspaper. But if you are carrying on your arbitral proceeding in a private chamber, in a private hall, in a private manner, so there need not be any disclosure to the media. To that extent, privacy or the confidentiality of the business is maintained. So arbitrator must be absolutely disinterested and impartial person. So he should, and in case arbitrator is interested in one or the other party, in such cases, he will be returned to have committed what is called as a professional misconduct. That will be treated as a misconduct on the part of the arbitrator. So he should be functioning as an impartial person. He is an extrajudicial tribunal whose decision is binding upon both the parties. How Arbitration Act has evolved in India? We had in 1940 Arbitration Act. Thereafter, we had United Nations Commission for International Trade Law, UNCITRAL Model Trade Law they brought in, and on the basis of which Indian Arbitration Act was reenacted in the year 1996. And in the 1996, the role of the court was also substantially reduced. The statement of the object and reasons to the act said that the old act had become outdated and there was a need to have an act which was more responsive to the contemporary or a day-to-day need. So 1996 act we had. This act and again underwent a amendment in the year 2015 and again in 2019, which I will take up with you a little later. So evolution of the Arbitration Act 1996, amongst the main objective to minimize the supervisory role of the court in the arbitral process and to provide that every final arbitral award is enforced in the same manner as if it was a decree or an order of a court. So much greater independence has been given to the arbitrator or arbitration law after 1996 amendment. So before we take up the specific provisions of the arbitration law, I want to take up certain terms such as arbitration, which I have taken up with you in a fairly good detail. Arbitration is a process of deciding case with the help of a person who is called arbitrator, and such arbitrator is appointed by the parties themselves. The easiest, so arbitration in the form of alternative is a way of resolving disputes outside the court. Dispute will be decided by one or more persons. They are called arbitrators. They are also called arbitral tribunal, which refers to a board of arbitration. They can also be called like that. And whatever award they give is called arbitration award. And arbitration is often used as a resolution of the commercial disputes. Before that, what is the difference between arbitration and negotiation? The easiest way to resolve the dispute is by negotiation. When you and I have a difference of opinion on our commercial dealing, the best thing is we ourselves should sit together, try to go into the background of what has led to the dispute, try to get into the mechanism of mutual give and take, and try to negotiate the deal and try to arrive at the resolution by the parties themselves without the help of an arbitrator, without the help of a conciliator, without the help of a negotiator, mediator, or anybody. If you and I have a dispute, we are the best person to resolve it, sit together on a day, second day, third day, and try to bring about an amicable settlement. Next is conciliation. But sometimes it becomes difficult whenever there is a dispute. Parties even stop talking to each other. They are not even into talking terms with each other. They do not understand the difficulty of the other party. In such cases, it is advisable to bring in some neutral or impartial person who should explain the facts of the case to both the parties, strengths and weaknesses of both the parties, and they try to bring in a voluntary resolution or bring them to a negotiation table, and the parties seek to reach an amicable dispute or settlement with the assistance of a conciliator who acts as a neutral third party. Conciliation. For most of many of you must have studied Indian Industrial Dispute Act. Industrial Dispute Act provides for a conciliator. Normally, conciliator is an officer of the Labor Department. So they come and facilitate negotiation between the parties to bring a resolution of the dispute. Conciliator shall assist the parties in an independent and impartial manner in their attempt to reach an amicable settlement of the dispute. Conciliator shall be guided by the principle of objectivity, fairness, justice, giving consideration to the rights and obligations of the parties, usage of the trade and all. So he tried to act as a catalyst in order to bring about the resolution to the dispute. Conciliator may also Conciliator may also conduct a conciliation proceeding in such manner as he considers appropriate, taking into account the circumstances of each case, or as wishes may be expressed by the parties. Conciliator may be at any stage of the conciliation proceeding make a proposal for the settlement of the dispute. Such proposal need not be in writing, but they may be only oral discussion. He tried to put forward before the litigants or before the disputing party what are the possible solutions which can be accepted by them, what are the ways, and he can also explain to them the consequences of, in case the parties go for a normal litigation, the consequences for both the parties may be expensive, time consuming, leading to uncertainty and all that. Mediation is a little step ahead of the conciliation. In this case, there is a lot of similarity between conciliation and mediation. In both the cases, there is an independent person separately selected by the parties themselves. But while in the case of a conciliation, the conciliator tried to clarify whereby the parties themselves arrive at the resolution of their dispute. But in the case of a mediation, a mediator goes a little deep. Mediation broadly refers to any instance in which a third party helps the other to reach an agreement. So mediation has a structure, timetable, dynamics, and ordinary negotiation, which ordinary negotiation lacks. But this man is a little more experienced. He also tries to make the parties make certain compromises. Mediation may not be always a perfect decision making, but at least that brings an end to the dispute. Mediator acts as a neutral party and facilitates rather than directs the process. Difference between arbitration and conciliation you already know. In case of a conciliation, it's the parties who themselves come to a resolution of the dispute under the supervision of a conciliator. The conciliator does not give any judgment. He need not necessarily even sign the conciliation statement. But the arbitrator is kind of an adjudicating authority who give a written decision which is enforceable like a decree of a court. Like that, mediation and conciliation, unlike conciliation who has an active role in the conciliation process, a mediator can propose a solution to end the dispute. He can even gives a calculation that you should do this, and then try to bring a middle solution. Mediator assists the parties throughout the mediation process to help them to find a solution to the dispute. What are the subjects of the alternate dispute resolution? There are certain matters which cannot be referred to arbitration. For example, matters of a criminal nature, illegal transactions, matrimonial matters, whether they can be referred to arbitration. Matrimonial matters have two aspects. One is the civil matters relating to, say, distribution of the property, right of the woman to compensation as a result of their divorce, or anything relating to the money matters. So these are the matters they can be referred to arbitration. But there are certain issues such as crime against the woman, certain atrocities done against them involving criminal action against the doers. Those matters cannot be referred to for arbitration. So what can be referred to for the purpose of arbitration are matters of a civil nature, matters involving breach of the contract and some compensation are available under that. Disputes of movable and immovable property, they can be referred to alternate dispute redressal, that is arbitration. The role of the mediator and conciliator, I have already told you. Appoint how the arbitrator is appointed. I have already said that it could be provided for in the agreement itself, or before the dispute has arisen, or he could also be appointed after the dispute has arisen by the party. Section 11A has been inserted to provide for the Supreme Court or wherever there is an international arbitration, that is one of the party is having a resident outside India or a company registered outside India. In such cases, arbitrator shall be appointed by the Supreme Court or a High Court while considering the application for appointment of the arbitrator. So section 11(6)(b) has been inserted to clarify the appointment of the arbitrator by a person or an institution. So in 1919, I just take up with you in next slide where the power has been given to the what is called as International Center for Alternate Dispute Resolution. Is the 2019 Act provide for setting up that institution. That institution also act as a database for all the arbitral decision, and they are competent to maintain a panel of arbitrator, and they can appoint arbitrator. Arbitrator has to be independent. In case he is not independent and shows extra interest in one party at the cost of another party, he will be deemed to have committed professional misconduct, and any award given by such arbitrator shall be void and shall be set aside by the court. Then 2015 enactment also provide for certain fees of the arbitrator. Unilateral or disproportionate fixation of the fees by several arbitrators has been the cause of concern. So subject of the fees of the arbitrator has been also issue of regret by the Supreme Court of India in case of Union of India versus Singh Builder. So where the court has said that fees should be reasonable. Some of the High Court has also issued guidelines relating to what should be the amount of fee, and the fee of the arbitrator should vary between rupees 45,000 to 30 lakh depending upon the sum involved in the dispute and the amount of work involved in the arbitration. Then section 1114 inserted in 2015 also provide for the purpose of determination of fee, the High Court may frame such rules as may be necessary. So many High Courts have framed the rules, and they have also provided the schedule of rates depending upon the qualification of the arbitrator. So conduct of the arbitral tribunal discourages the practice of giving baseless adjournment, frequent adjournment, because these are the things which are peculiar to the court, which court gives so many adjournment. So hearing of the arbitration must be done on a day-to-day basis without much adjournment. And if the party seeks adjournment without sufficient cause, then the arbitrator has also got a power to impose upon them exemplary costs. Then time limit is also prescribed by the guideline that arbitration decision must be given within a period of 12 months. The period can be extended by the parties up to 6 months by mutual consent, and any fee payable to the arbitral tribunal can be reduced up to 5% for each month of delay beyond this 1 year and 6 months of this period. Beyond 18 months, the fees of the arbitral tribunal shall be reduced by 5% every month. So if it is delayed by 12 months more than 18 months, so in case their fees will stand reduced by 60%. If the arbitration or the award is not made within that period, mandate of the then the very mandate of the arbitrator terminates. However, court can further extend the mandate by a suitable terms and conditions. You can also go for fast track arbitration. In such cases, in case both the parties agree, they may agree to make written submissions to the arbitrator, and in such cases, there may not be any oral arguments except wherever some clarification is required by the arbitrator. So oral hearings may be dispensed with, as a result of which arbitrator should be able to decide fairly quickly, and in such cases, the arbitral award shall be made within 6 months of the appointment of the arbitrator. So international commercial arbitration means where one of the parties is a normally resident outside India, or in case there are two companies are party to the dispute, one of the company is incorporated outside India, a company, this I have already taken up. So amendment in 2015, the Law Commission of India had brought out a report, and in that report, they have, on the basis of that report, amendments have been proposed in the year 2015, And the object of that amendment was to ensure speedy disposal with minimum court intervention. It also provided for that court can set aside an arbitral award if the court finds that arbitral award is in conflict with public policy in India. Similarly, it also provided for foreign arbitral awards. For enforcement of the arbitral award, also there is a now easy mechanism available. The award has the same force as that of a decree or a order of a court, so it can be straight away sent for enforcement. The power of the tribunal to order interim relief, this also has been given in the before 2015. The arbitrator did not have a power to give interim relief. Now they can also give a stay order or an interim relief till the finalization of the issue of the final order. Form and content of the award should be in writing, signed by the members of the arbitral tribunal. Tribunal may at times or during the proceeding make an interim award. I have already said. In case of an award, payment of money, the tribunal may also award interest. Award may state the date and place of the arbitration, cost of the arbitration, party entitled to the cost, manner in which the cost shall be paid. Importance of the arbitration for registered valuers. The valuer may be required to function as an arbitrator in many cases for resolution of the dispute between two or more parties regarding the fair value of the property. Like that, knowledge of the law of arbitration is therefore important for professional valuers. Let me also take up with you a little bit about 2019 amendment. 2019 amendment provides for setting up of All India International Center for Alternate Dispute Resolution, in which the president of the international arbitration shall be independent body, and the power of the Supreme Court or a High Court can also designate another arbitral institutions called Arbitration Council of India for promotion of arbitration, mediation, conciliation, and other form of alternate dispute resolution. Then functions of the Arbitration Council of India shall be, Arbitration Council of India would be framing of policies regarding grading of the arbitral institution, like it is done by ICRA or by CRISIL. इस तरह की rating कर सकते हैं of the different institution. Accrediting of the arbitrators depending upon their qualification, making policies for establishment, operation, maintenance of the uniform professional standards for all the alternate dispute resolution matter, maintaining depository of arbitral awards made available in India or abroad, then time limit for appointment of arbitrator. Amendment aims to bring in arbitration of excellent quality. So that's what the objective is, to reduce the burden on the courts, to provide for exclusive list of arbitrators to be chosen from. That means they can maintain the panel of arbitrators to speed up the arbitral processes. So all these things are provided. The Supreme Court or High Court shall have the power to designate arbitral institutions from time to time. So High Court can also constitute a panel of arbitrators. So this is all I wanted to take up with you today. In case you have any question, please feel free to ask. Any question, friends?
Sir, can after giving the decision of the arbiter,
Yes.
can anyone go to court if he feels unsatisfied?
In appeal, yes. Just as even if you take a decision from a high court, and if one of the party is dissatisfied, and if the party feels that justice has not been done to them, so they can go to Supreme Court. If somebody is take a decision of the district court, he can go to the in appeal to the High Court. Like that, a decision of the arbitrator, if somebody is unhappy, so they can challenge the decision of the arbitrator in a competent court, mostly High Court. Any other question?
What is the time limitation for this?
1 year. Normally 1 year. I said in the somewhere in between that the parties can agree to grant an extension up to 6 months, and any extension beyond that can be given by the court, and the court, while giving, can also impose a restriction that any delay beyond a period of say 18 months will involve reduction in the fee of the arbitrator by 5% every month.
My question is, when the arbitrator has given some direction, if other party is not happy, within that stipulation, how soon they can go to the court?
First of all, okay, if the other power, yes, then in any case, appeal, so one can always file. Power to appeal, the right to appeal is always there. But in case somebody is seeking undue extensions, uncalled for extension, just to adopt the delay tactics, then the arbitrator has got a power to impose exemplary damages or cost on the party which seeks extension. Any other question?
Sir, what is minimum qualification required for arbitration?
It's the choice of the parties, but normally a person should have at least some knowledge about the industry. If you and I have a dispute, we will not appoint a rickshawala as an arbitrator. We will always want to know that the person who is appointed has a confidence of both of us, and the person who is appointed knows the subject in which we are dealing with. So because as such, there is no technical or educational qualification prescribed, but the Council of Arbitration or International Center for Alternate Dispute Resolution, they will normally maintain the profile of the persons who at least have some background in, say, engineering, textile, telecom, or whatever industry you feel that where maximum disputes are taking place.
Means the knowledgeable person of respective field in the case of respective arbitration.
Yes. Exactly.
Sir, arbitration works in case of builders who are delaying the possession to customers.
Arbitration, sorry.
I'm saying arbitration works between builders who are delaying possession and the customers who are like fighting in court or something.
It can be there, but now the customers or the home buyers has got much powerful remedy in the shape of RERA, because arbitrator, even if you appoint that the likelihood of the arbitrator getting influenced by the builder is much more than by the consumer, the house buyer, what influence you can do. But now consumer has got a much powerful remedy by way of making application to RERA or even to the consumer forum.
Sir, just one more question. There was a clause where there is a right, there is a remedy.
Yes.
And just as an example, I was thinking, does it include like road contractors are made to work a particular specification of the road, and if they are making full bumps and all, it causes the consumers to causes extra damage to our cars because of heightened service cost and all. So that is included as the right there.
That right is available, but then who has provided you the right to use the roads? Since you pay the road tax and you also pay at times the toll tax, in such cases, normally the roads are maintained by Highway Authority of India, but sometimes there is a contract between Highway Authority of India and some concessionaire who is given the responsibility of building the road and then charging toll. In such cases, you can file a compensation, you can claim a compensation from the concessionaire. Because now it becomes a virtually contract. If you are traveling 300 kilometers on a road, you know whether the road is maintained by PWD or by Highway Authority or some BOT. On the BOT method, some private contractor has been given the power or obligation to maintain that road. To the respective authority, you can seek compensation.
Okay, sir.
Sir, I have a question. Because with the passage of time, lot of government intervention and the government role in doing that kind of a social development is reducing, and lot of private parties have started taking up that role. Okay, any other question, friend?
Sir, what is the
What is the? Hello.
Hello. I have a question. The arbitrator which is appointed has to have the consent of both the parties?
Yes.
Then only he can appoint. And suppose
Yes.
if you are not agreeing to one of the arbiters or maybe
yes. Yes. And this agreement could be between the two parties, could be in the beginning itself, how they will appoint. And then when you both the litigant parties goes to the arbitrator, then arbitrator also has to agree.
Okay.
If you and I have a difference or a dispute and we decide that the dispute resolution will be done by Amit Shah, he may not agree to accept that our consent.
Yes, sir.
Right? He should also agree.
Right. Thank you.
Any other question, friends?
No, sir, thanks.
So with this,
Very nice
friends, thank you very much for your very active participation. I'm quite thrilled. I spent a very energetic